Thank you.
I think we're going to keep because there's only 15, and then we can maybe the other ones are all unopposed. So I think we're going to try to finish.
Hi, sorry about that. I realized I was muted. For anyone following along on YouTube, can you please switch over to the PM session 1 stream, as the time has run out on the first stream. Thank you.
Okay, Mr. Chair, we're ready to continue with item 12.
Okay, so the next
And
speaker is 68 Runnymede, either Rizard or Maria Adamczyk. Who was the speaker for this property?
Richard.
Richard?
It's Richard Adamczyk, 68 Runnymede.
Welcome, sir. Let us know what your concerns are, please.
Yes, I guess the concern is that we agree with 66 Runnymede that when we walk out on the back of our backyard, we're going to see a wall 9.4 meters by 21, 9.4 meters by 21 feet going right into the garage, and that's going to block completely the view, the sunlight, and so on. Another thing is, again, in agreement with Darren Parker, the front of the house, it's going to be 48 feet from the sidewalk. So unless they move it front to a little bit 10 feet back, it's going to be completely the only house on Runnymede Street that is going to be so far back starting, just to accommodate 2 parking spots. One being the carport, which probably carports belong in Mississauga, not really in Toronto, not in the Swansea area, and another one car parked behind it. So that's basically the 2 concerns that I have, and we did some measurements, and the house is going to be larger, the footprint is going to be larger than current house, and it's going to be moved back. Even with the removal of the variance number 2, it's still going to be tremendous building, piece of wall standing next to the driveway. So I feel sorry for 66 Runnymede that they're going to have to facing that. Other than that, I guess my complaint would be due to a 6th of November mailing of the letter, trying to rush, gather some information. There was no consultation from the builder whatsoever, no trying to contact us. So we didn't get any package. We had to find out on November 7 and 8. On the weekend, I had to go and look on all the documentation published on the website. So basically, we are opposing the way the house is being proposed to be built, unless they move the house and eliminate the 2 spaces for cars in front of the house, which is going to move the house almost 50 feet away from the sidewalk. So that's all, and I hope you take my consideration and make the appropriate decision.
Okay,
Swansea Village has been always small, community, family oriented, and now we're seeing something becoming not in our neighborhood, fitting with the design of all the other houses.
Okay, thank you, sir.
Thank you very much.
Thank you. Nick Singh is the next speaker from the Swansea ratepayers. I see we had the deferral, but you actually have a substantive letter for this as well. And then you mentioned something about a 15-foot second floor height. Perhaps you can clarify that in your presentation, sir, and let me know what the concerns of the Swansea ratepayers are on this application.
Sure. Just to set the stage for you, I mean, these
Nick, can you try to speak up, speak there more directly? I'm having trouble hearing you.
Okay.
Much better.
These are small properties. They're close together, quite close together. So small changes have a very big impact.
Yeah.
I agree FSI is not outrageous, but the rear extension is going to be a big change. And together with the extra height, it means a lot to these neighbors that are close together. It means loss of sunlight and it being closed in. The wall that's going to be created from the front of the building right to the rear where it interacts with the garage is going to be basically a solid line which covers that entire property line there. The 15-foot ceiling, if you go to page A05 of the plans that are submitted, you'll see that the second floor
Mm-hmm.
starts at 14 feet 9 inches, and the top of the roof is 30 feet 9 inches. So you do the calculation there, you got 16 feet. So
That's
it's
to
a pretty
the.
tall.
Is that
Yeah,
like
it's
for a
pretty tall.
skylight? Does that say this, the skylight effect we're seeing there, and because it goes to 22.7 to the main wall, and then to the roof it goes up again another 8 feet.
Yeah,
And I guess
that's
considered
skylight.
height. That's height. Yeah.
Yeah, if
I think they're only 0.4 of a meter over.
If there's a ceiling in there, talking about a 15-foot ceiling, right? The skylights being open, you could drop that roof down without a problem, and you wouldn't need that extra. So we think a redesign on that height would help.
That's
the
really not
massing.
before us. But you're saying it could have been brought down to comply, and they'd only have to bring it down, I
Correct.
think, 0.4 of a meter to comply. But you're saying that was not necessary. I believe your letter.
In my letter? My letter is saying that it could be redesigned.
Yes.
Yes. Okay. The other concern I have about what we have before us just now is we are changing what we're looking at. We're talking about moving the house. We'd like to see where it's being moved to. We'd like to see what the setbacks actually will be. Are we meeting the setback for the front, the average between the two houses, and how that's gonna work out, and how it will work out with the parking. So until we have a clear drawing in front of us, we aren't quite sure what we're going to be looking at. We'd recommend that this get deferred.
Okay, we've already been hearing this, but yeah, you had written your general deferral about the lack of notice, but you're saying now it should be deferred, not for that, but for the fact that it should be redesigned, as opposed to accepted or refused here on what's before us, because that's what's before us here.
Yeah, to be frank, there are two reasons to.
Okay, and I don't know
defer
what.
it.
So there was no
We dealt
the
with that at the
consultation
beginning.
issues we've heard again are an issue with this.
Mm.
If he was aware of that there was going to be this objection or not. So, okay, so if that's what you have to say. Is there anything you'd like to add before we move on to the next speaker, Mr. Singh?
Yes, you have heard about the character of the neighborhood being a concern, and we share that concern too. This building doesn't conform to what we have on the street.
Right, including the 2-car parking at the front, the carport. I believe
Yes,
the
correct.
applicant has explained that it's for safety purposes and not able to access the one at the rear. So, okay, so we have one speaker registered again for Renee Nixon from 67 Beresford.
Hi there.
Hello,
Hello. Hi there. Hear me?
go ahead.
Can you hear me?
Keep talking. Hello?
Can you hear me now?
Yes.
Okay. So,
Please start off by
thankfully,
stating your name and address.
yes, my name is Rennie Nixon. I'm at 67 Beresford. That's directly behind.
Okay, can
the
you try to
applicant
project
here.
a little bit because you're trailing off and you're very faint? And we
Sorry
want to
about
hear
that.
what you have
How's
to
this?
say.
Okay. So, I as well got my letter 2 days before the deadline. Thankfully, the letters of opposition were quite thorough, so I won't repeat all of these excellent points, and I support all of the opposition. I'm going to suffer the most, or one of the most, of all the neighbors, because this house is going to end up in my kitchen. And it's really the 2-car parking in the front that's really driving the house backwards. towards my property. And I think that they need to rethink this whole plan. It's excessive. There's nothing minor about anything proposed here, and I really sympathize with the neighbors just on the north of this proposal, because they're going to be looking at a brick wall. Very little green space. The previous owners, who I knew, Doug and Luba, had no problem parking in front of their garage there. The you know, obviously the carport is not keeping with the character of the neighborhood. The variance for the exceeding the height is going to punish me further. You know, I'm going to lose even more sunlight, and I'm going to be boxed in. And I guess I've lived in Swansea for 30 years, and the trend of allowing bigger and bigger builds and variances is eroding what people seek by wanting to move to Swansea. So I guess they want to pave paradise to put up a parking lot. So I would like to see this deferred, redesigned, and brought into line with what we see around the neighborhood. And that's about it for me. Thank you.
Okay, thank you, Mr. Nixon. And you're directly behind.
Correct.
Yeah. Okay, let's go back to Mr. Baskerville to respond to the concerns of the neighbors. We're not at this point, hearing this, we're not going to defer if it's going to be redesigned. We're in the middle of this application. No one asked for a deferral, so please respond, and we have to take this into committee for a decision.
Mr. Chair, before we move on to the applicant,
Yep.
Ms. Chester is here. She was using a different number, so I'm going to unmute her and get her opinion.
Okay, that's the neighbor at 70 that you said you couldn't reach.
Yeah.
So we have her now back on the line.
Hi there. Thanks so much for providing me with the time. The very first point I just want to make with respect to timing, I really appreciate all of the effort that Tom has gone to in the past recent days to consult with a couple of the neighbors. I, however, don't feel that timing should really dictate permanent changes that they're proposing to our neighborhood. They are very significant, and I appreciate that while 2 or 3 meters may not sound significant to those who live in other neighborhoods, we live on basically posted sized lots, and we've decided to do so, and we love it here, but we don't want to be overshadowed, and that is what will happen with these significant changes. I won't harp on that. I think that the idea that the house is going back a very far way, even despite number 2 being removed from the variances, has already been overviewed enough by my neighbors, and I completely agree with them.
Okay.
And just there's 2 other concerns that I would just like to reiterate here. So first, the carports. So this is a really suburban typology. We do live in an urban area. Swansea, we're really close together, and the city planners at the City of Toronto have done a wonderful job trying to encourage everyone to use alternate modes of transportation to really decrease our reliance on cars for so many reasons. This carport is essentially imprinting on our environment a structure that says cars are meant to be here. And if they are going to move the building forward, then that carport would also be presumably being brought forward on the lot. I have some concerns about that influencing visibility of cars coming up and down the road. Runnymede is a relatively busy road. There's a bus on it. So I would want to ensure that we have everyone around has full visibility of north and south when people are leaving their driveways. And further to that, as others have mentioned, there is currently parking in the back. So it's not an issue that they don't have parking right now. It is an issue that is secondary to their plans. So it's something that really I think can probably be worked around. And carports also, I could potentially not be safer. I know that in the cover letter, it was cited as a safety concern that there needed to be a carport. To me, people could hide in a carport. Animals can hide in a carport. We've had issues with our neighbors on other roads having animals that are living in their garages that are condemned. So like if you have an open carport that provides shelter, it has potential to house not only animals, but also if you have concerns about safety for, I'm not sure why you would buy in a neighborhood that you felt you were unsafe, but that's secondary. That also potentially poses a problem. And the last concern I have about the carport is the plans are just simply not clear. Some of the elevations suggest that there would be interior space projecting over the carport. So that carport is not just like an open structure. It's actually, it looks to me, and perhaps I'm not understanding the drawings accurately, but it looks to me that it is actually providing additional floor space for part of the bedroom, which is on the second story of the dwelling. So I can understand from like an architectural design perspective why you would want the carport there because it's providing you with additional space to build upon, but that also suggests that we don't really understand what's going to happen if they're going to move the dwelling forward. So aligned with others who have recommended that this get deferred in light of the new information that was brought forward by Mr. Baskerville today, I am completely aligned and recommend that we do defer this. I think there's been great conversation, it sounds like, in the past couple of days, and we can probably come to a conclusion amongst ourselves that will then hopefully go unopposed at the future hearing. Thanks so much for your time.
Unfortunately, after listening to this, I don't know, about 45 minutes or so, or we're not deferring at this point. Someone was at their option to ask at the outset. Mr. Baskerville did not ask for that. He said he was eliminating the variance number 2. And so we have it. We're going to be making a decision on this. Appreciate your comments. And I think a carport is supposed to be open on 3 sides, but in order for it to be carport. But you're saying something perhaps we can hear back in rebuttal that he's going to use some additional building space. You're talking about the roof of the carport is going to be used for a balcony, but perhaps we can have, because a number of people have asked the applicant, what's happening with moving it, what's happening with this. So let's go back to Mr. Baskerville to answer your concerns and those of the other neighbors that we've been listening to, and then we'll bring it in for a decision. So maybe he has some things he has to clarify. So I appreciate your comments. Is that basically you're done? Ms. Chester? Okay. So let's go back, Mr. Baskerville. We heard a lot of comments from the neighbors. They feel it's out of character, that this carport situation doesn't work. And we've heard all their other concerns, notwithstanding you've eliminated a variance and you only have 3 variances left. So back in your court.
Thank you, Mr. Chair. Many of the discussions or areas of concerns are not one that arise from the variances. They're ones that could exist as of right under the existing zoning, including the apparent 18-foot extension of the rear of this home beyond that at 66. I mean, that's just what the zoning permits right now. Obviously, we're not going to be able to interfere with the right-of-way. I don't think any of those issues, although I can understand the concerns, we know that we have to, respect all of the requirements before we could build. There is some built space over top of the carport, basically just in line with the front door of the home, so that it's approximately 2.5 meters of the back of the carport would have a second floor built above it. I think that was fairly clear in the plans, although I can understand, it can be tough to follow in some ways. Where the front of the dwelling is, it's basically, across the front door all the way up to the second floor is on one plane. The only thing projecting is the carport. There are many examples of garages and carports in the area. Some have been built due to grade into a basement level. Others are elevated. This would certainly not be a new precedent. we'd like to get that closer to the street so that the dwelling face is closer to the street. We believe that we can do that with the variances as they're presently proposed. There was mention of 48-foot driveway and a 50-foot driveway and so on. None of that is proposed even on the plan without moving anything. The front of the carport was set at 3.32 meters back, which is the average of the fronts of the homes on either side. But we now know that we're allowed to encroach into that space with that structure and bring the front of this building up closer to the fronts of the others. There was a 48, the actual dimension proposed to the front door is 7.2 meters. The entire length of the carport was 9.7 meters. So there's no 48 feet of driveway. There's no ability to park a second car in front. The issue around the height is really just, it's a design issue. The height that we're proposing is well below what's been approved elsewhere in the neighborhood, many in excess of 10 and even 11 meters. We're looking for 0.4. So it's our submission that the variances that we're looking for are minor, and that given these variances, we can work the plan to stay well within what's appropriate for the neighborhood.
Okay, you mentioned lots of examples of carports, but the neighbors are saying there are no. It is out of character for this neighborhood. So are you telling us where these carports are? And same thing with the height. I know it's only 0.4, but I guess they're mentioning it's because of the open ceiling and the skylight. So again, it's not just there's lots of approvals at 9.4, but is that on a 3-story house? Is there some context for what you're telling us, or are we supposed to take it at face value that there's other carports and there's variance at the 9.4? But Mr. Singh's comment is that even though it's only 0.4, is it truly necessary because it's a 15-foot ceiling? And then again, same thing about the carports. We've heard a lot of to just say, well, there's lots of them in the neighborhood. Well, we've heard from the neighbors who live in the neighborhood that there aren't. So where are those ones, and where are their pictures or copies of notices of decision showing those other carports? That would be my follow-up question on what you've had to say. Can you tell us where those carports are and how the height context is the same too?
So in terms of the height, it's really just a design element. If it could easily be eliminated, it doesn't. The height of the roof doesn't have anything to do necessarily with the height of the ceiling inside. There's not, there's no decision made to have a 15-foot ceiling. If the height were not approved, we would simply lower the peak of the roof to comply.
Okay. And what about the carport?
So the carport, I don't have other addresses to offer you in the time that's been available. I don't have the photos and the addresses to make that case conclusively. I think it's well known that there are many in the neighborhood, but I can't give you the addresses of any of them today.
Okay. Thank you, Mr. Baskerville. Committee members, any follow-up questions for Mr. Baskerville or any of the neighbors for that matter? Or are we ready for a motion?
I'm curious about the shared garage in the rear yard, whether, if you lob off half of it, if the structure can stand on its own, or whether is there a supporting wall in the middle, how that functions, and whether this new house is going to function with that garage in the rear yard, because the easement does extend to the rear yard. So just want to know about that.
For our point of view, there is a demising wall in the garage. We would never just simply cut it off at the demising wall and leave it looking oddly like that. I think a reworking of the garages would be the only appropriate way to deal with it. Something that we haven't turned our minds to at all at this point. But yes, there is a structural wall at what we think to be the property line. It looks, according to the survey, that it would be on property line. We did step the footprint of the house away from 66 at the rear of the home, provided an extra, I think it's 1.2 meters in width away from it at that point as well. And without the variance, of course, then there is more room between the house and the garage. But there's no ability to get a car in there. My wife and I have tried. If you had a very small car, you could do it. And then the question is, if you got the car into the garage, could you open the car door to get out? And the answer for us is no, you can't. It's just not practical. And for us to park in front of the garage is impossible because then we're blocking part of the easement, and it's not workable for us.
Any further questions, or is someone ready to make a motion?
I'll move for approval. Believe that the application is minor in nature, meets the 4 tests. I understand it's also subject to
I think there's a
urban forestry.
Forestry 3.
Yep, along with removal of variance number 2.
Great. Thank you, Ms. McCloskey. Do we have a seconder for that motion?
I'll second.
Okay, all in favor? Okay, I'm opposed. So the motion carries 3-1. Thank you, neighbors. Thank you, applicant. Okay, next application is item number 13. This is an unopposed application. There's no one registered to speak, and we don't have any letters of opposition. We only have neighbors in support. Hold on. Speaker,
Yeah.
The agent is Seva Mikovic, and this is an application for a 3rd-story addition above the existing dwelling, a new 3rd-story rear platform, a new front porch, and a new rear detached garage. There are 9 variances. We have supporting material, 3D renderings. We have a condition of approval being requested by community planning in event of approval, that there be screening on the deck, and we have neighbors in support. Mr. Mikovic.
Good afternoon.
Good afternoon. I don't think we need a presentation for you. Let's just see if we've reviewed your supporting materials, which are very helpful. You're aware of the planning condition. Let's see if committee members have any questions for you. And if not,
Okay.
someone's ready to make a motion. You're okay with the community planning condition, sir?
I am. Yeah, we're okay with those conditions, and we're also okay with the urban forestry conditions as well.
Right, which is condition number 2.
Correct.
That's all there is. Okay.
Okay, I'll move for approval of variances requested or minor in nature and meet the 4 tests in the Planning Act, subject to planning condition regarding the deck and screening, and subject to the forestry condition for a tree permit.
Thank you, Mr. Palmer. I have a seconder for that motion. Ms. Reddick. All in favor? Unanimous approval. Thank you, sir.
Great. Thank you very much. Thank you.
Okay. Next application, also unopposed, item number 14-415, Roncesvalles. This is an application for 2-story rear addition, which will contain 2 additional units. And we have on this application only one variance, I believe. It's the parking space, 2 required, only 1 being provided, very straightforward. And we have support from 402 to 404. I believe it's a building, Roncesvalles, across the street. Speaker is Sean Galbraith. Mr. Galbraith, welcome.
Thank you.
Okay. Unopposed application, very straightforward, very simple, 1 variance. Let's see if committee members have any questions or if we're ready for a motion. And we do have a letter of support. Oh, I just said that, from 402 to 404.
I'll move to approve. Consider the application minor in nature and meets the 4 tests. Pretty
Thank you, Mr.
straightforward.
Lasky. Seconder for that, Ms. Roddick. All in favor? Unanimous approval. Thank you, Mr. Galbraith.
Thank you. Have a good day.
Good job. Item number 15. This one is opposed. 3 DURIE. It's to construct the 3-story rear addition, second and third story additions above the existing dwelling, and to create a secondary suite in the basement. There are 7 variances. We have opposition, 12 oppositions, letters of opposition. We have transportation is okay. We got that memo twice. There was reference to a planning memo, but there is no planning memo. And so transportation there's no problem with them maintaining the existing front yard parking space. And we have opposition concerns with the height and size from 5 DURIE and from, we have a comment from former councillor Sarah Doucette as well about the process and the deferral issues. She's talking about a deferral. So we have quite a number of opposition letters, I believe 12. And the applicant is Arlene Beaumont. And we have registered speakers, just to make sure, Paul, that they're all here, still registered. We haven't lost any through attrition. We have 5 DURIE who wrote the letter, 30 Beresford. We have Nick Singh, again, from Swansea Ratepayers, and Daryl Elliott from 4 DURIE. Is that correct? Okay. Okay, so let's go to Arlene Beaumont, the agent. Arlene Beaumont?
Sorry, I was muted. Can you hear me?
Yes, we can, loud and clear.
Hello?
Yes, we can hear you.
Okay, sorry, I'm sorry, I was muted. So we're here today to request 7 variances, as you mentioned. It should be noted that the property owner intends to retain at least 50% of the existing foundation of the existing home, and then we'll be doing a new dwelling above.
Yep.
I would like to start by talking about variances 6 and 7, which were the front yard parking spaces. As you noted, Mr. Chair, we do have a letter from transportation saying they have no objection. There has been a permit in place for front yard parking for years, so it's not anything that's new. The dimensions of the parking space, again, have been the same for years and will not change as a result of the new construction. Therefore, anyone who intends to live at this house will have to satisfy themselves that the parking space can accommodate their vehicle. I've read the letter of objections from the neighbors and the Swansea Residents Association, and it would appear that the chief concerns are the proposed height and the variance for floor space index. With respect to the height, there appears to be some confusion among the neighbors. The proposed height under the city-wide bylaw is 9.98 meters. The proposed height under the old City of Toronto bylaw is much higher at 11.39 meters. The difference is the way that the height is calculated under both the bylaws. For a property such as this one, which slopes considerably from side to side and from front to back, the height as calculated under the old City of Toronto bylaw is skewed by these slopes. So this explains the big difference in our proposed heights under both bylaws. I think it's important to note that the height of the dwelling facing the street will be 9.98 meters.
Okay, so it's a meter over what's permitted, correct? We're looking at the less restrictive bylaw, which is newer bylaw, and the old one from 86 is going to fall away in any event, right? So,
yeah, that's correct.
Okay.
On that note, I have reviewed Committee of Adjustment decisions for variance applications in the neighborhood as a whole and on Durie Street and adjacent streets, and I specifically looked at FSI and height. There have been a number of variances approved for FSI and height that are significantly greater than the variances we are requesting today. Although these previously approved variances do not set a precedent, they do give us a good indication of how the neighborhood is developing and the character that is emerging as older homes are replaced by the new builds. The proposed dwelling at 3 Durie will be similar in character to other new builds on Durie and adjacent streets, and the height and FSI variances are in the mid-range of what has been previously approved by this committee. It should also be noted that the proposed dwelling complies with all the provisions for setbacks and for dwelling depth. Finally, I'd like to speak to the variances for front and rear wall height. This is a flat roofed home. I'm sorry, I'm looking at the screen and that's not those aren't my plans. I don't know where those plans came from, but they're not mine. That's not the home we're proposing. I don't know.
Oh, that was in the additional
Yes.
material, yeah.
So the variances for front and rear wall height, this is a flat roofed dwelling. So the main walls will be higher than would be the case for a sloped roofed dwelling with the same overall height. However, in the design of the exterior of the home, the architect has provided a roof feature on the front of the dwelling that serves to break up that front wall vertically. On the rear of the home, there is a deck at the 3rd floor level and a balcony off the ground floor that also serves to visually break up the rear wall of the home. In summary, the variances that we are requesting are in keeping with those that have been approved in other nearby new builds, and the variances meet the 4 tests of the Planning Act within the context of this neighborhood. And I'm very happy to answer any questions. If you want to know the addresses and the variances that were approved for nearby homes for height and FSI, I have those, and I'm happy to provide that information to you.
You haven't done that already? Like,
I have done my
you're-
homework.
okay, and I'm saying, but you're asking for a FSI, floor space index of, you're from 0.6 to 1.09. You surely you should have,
Yes.
if that's within the character of the neighborhood, you really should have, haven't included any precedents on the street or neighborhood more widely to showing where people on the street have gotten that type of a variance, and because they're small lots, it's
Would you like?
expensive. So can you give
I
us
can
some
provide some
addresses on approvals to help your cause?
Sure.
On Durie, where FSI. Oh yeah, the other thing is, what is the current FSI? This is not a new build. This is an addition. So it's always relevant to know what you're starting out with. Do you know what you're starting out with now?
So I can tell you that I don't have the actual FSI, but I can tell you what the existing floor space is.
Mm-hmm.
And the existing total floor space for this house is 100.74 square meters, which is an FSI of 0.46.
Okay, so you're under
We're
what's
asking for
yeah.
Under what is the
Yeah,
what
0.6 is
maximum
permitted,
But I
130
will
square
also
meters.
give yes.
Okay.
In terms of areas is just on Durie. 7 Durie Street, 2015, FSI approved was 1.14, height approved was 10.8. 13 Durie, 2012, FSI approved was 1.26, height approved 10.6. 15 Durie Street, 2018, FSI approved was 1.16, height approved 10.13. 34 Durie Street, 2015, FSI approved was 1.14. I did not see a height variance for that one. I also have some variances that were approved on Beresford. They're all 2018. So Beresford is 1 street over.
Sorry, you're at 7 minutes.
No, but I asked her a question.
Oh, sorry.
I asked her a question, and I think this is very valuable to help your cause, showing us actual addresses in the vicinity on Beresford and Durie that shows that over 1 times coverage. So that I think was very helpful to your cause of giving to us actual addresses. So thank you for answering that question. And the chair is the Secretary Treasurer. We have to move forward. So let's go. Let's go to the neighbors, I guess. if because we've let you, you're well beyond. So the neighbor at 5 Durie, the Gordons, either Jane Laster Gordon or Colin Gordon, I don't know who's speaking.
Yeah, I'm Colin Gordon, and I'll be speaking.
Welcome, sir.
My wife, Jane Laster Gordon, and I are the property owners of 5 Durie Street, immediately north of 3 Durie.
Mm-hmm.
We object to the application for the following reasons. The floor space, the proposed floor space of 1.09 times area of the lot is 81.6% greater than the
Yes,
permitted
sir.
floor
Sir, I
space.
see. If you're going to read from your, I don't think we have time for you to read from your read your letter out, because if you can just kind of summarize the. But again, you're
right.
saying it's not minor. You're giving us a percentage, but that's why I asked the applicant to
actually-
give us some precedence. So, please continue.
Okay. All right. Okay. It's the one of the things I want to say is that the total the additional living space in the basement, giving a total of 6 bedrooms, means that the rear of the house will be 4 stories, as can be seen in the east elevation architect's diagram A2.3. I will assume that you have read all my letter, but I want to talk about the height, because the agent was talking about previous houses built in the street. All of them were built to start at a lower grade than the street level. So none of them appear to be as high as the proposed height of number 3.
Number 3 is the highest one.
Number 3 is right at the top of the street, and adding 2 additional stories will mean that it'll loom over the entire neighborhood. The overall length I have mentioned in our letter, and I'll assume you've read that. But the reduction in outside backyard usable green space resulting means a reduced space for the urban wildlife that currently make use of it. And this greatly impacts and damages the current ecological balance, and with all of the underground streams in this area, will increase the risk of flooding in the neighborhood. The proposed height of the altered dwelling at 11.39 meters is 25.6% higher. Now, we've already discussed that, and I'll move on, but it's not a minor variance and is not in keeping with the look and feel of the neighborhood. The glazing, the proposed balcony and glazing at the northeast side of the altered dwelling directly overlooks our property. We object to this proposal on the grounds of invasion of our privacy. As far as the foundation is concerned, removal of the existing framed wall and the construction of a new extension and refiguring retaining wall is going to require digging below our foundation at less than 1 meter away from our house. And the grade there has a steep slope. How is this going to be achieved without disturbing our home and retaining walls? We're going to need a guarantee that our house will not be compromised in any way due to any and all of the renovations that take place at 3 Durie Street. Currently, the access to the north side between number 3 and number 5 requires climbing or jumping about 1 meter. So we're requesting easy access, such as concrete steps and a cement path between the properties. The last 2 photographs attached to our letter of objection illustrate the height differential between 3 Durie and our property. This illustrates the last 2 photographs, please. This illustrates how the 11.39 meter height will obstruct our sunlight at the rear of our house, and also emphasizes the risk of flooding as a result of the construction of the extension. So I will leave it there on the basis that you have read my letter thoroughly. Please bear in mind that we're talking about the height. The other houses that were mentioned by the agent do all start at lower levels than the street level, quite considerably lower. Okay, I'm done.
Thank you, sir. Does anyone have any questions for Mr. Gordon before we move over to the next speaker? Okay. Monica Sharska from 30 Beresford.
Hello, my name is Monika Kucharska. I'm from 30 Beresford Avenue. Do you hear me?
Yes, loud and clear.
Thank you. Very good. I just wanted to point out that together with my letter of objection, there was sort of a list of signatures from neighbors around this whole block, including the neighbors in the back of the proposed for development property. There was a total of 30 neighbors who had signed up this letter of objection of mine, concurring with what I say, and representing a total of 23 households in this block. Again, just like the previous speaker, I assume you had read very carefully my letter and all the objections towards particular variances. So I'll try to summarize very quickly. And I just want to say I'm an architectural designer myself, usually standing on the other side of the fence at Committee of Adjustment hearings. And I want to make it clear that I'm not against the developments of this neighborhood, as long as they are thoughtful and truly abide by the 4 points of the reasons for the Committee of Adjustment approval, which is the maintaining of the intents of zoning bylaw, official plan, desirability of the variances for the proper development of the land, and the fact the variances are being minor. This proposal does not comply with any of these 4 points in my book when it's asking for 1.09 FSI versus 0.6 allowed, height of the walls in excess of 2.98 meters over the allowed 7 meters. The height of the building is not that much of an issue as the height of the walls. This is where the transgression is much greater. Once again, it's 2.98 meters over 7 meters allowed in this neighborhood, which is more than 50% more. And the parking of a vehicle, which I understand it's been an existing situation, but again, it's not a very good, it's not an improvement, this property, when the vehicle is actually literally butting its rear end against the sidewalk. So none of these are minor, and it means that the general intent and purpose of the zoning bylaw is not kept. It's also not maintaining the general intent of official plan or desirability of the proper land development of the land. If we consider that we are creating a very tall structure on the top of the hill, unlike the other precedents where at the sort of valley of the hill, the precedents that the applicant had presented, which means this structure will be looming anywhere between 12 meters to 14, maybe even 15 meters over the rear and side neighbors, affecting the views of a number of properties that are located much further than just immediately adjacent neighbors. The side neighbor, the one that was just speaking right now, to the north, will look up to 12.9 meters above their sort of a level of the property in the rear of the property, 12.9 meters. So there's one more thing that I wanted to mention, that there is a secondary suite in the basement proposed with full kitchen, like it's a full separate suite, which really makes it a duplex where the length of the
Well,
house
I
should be
don't know when it's in the
40 meters.
basement. I believe they're entitled to a basement apartment. It's not considered a duplex.
Right,
Is that correct?
right. But I just keep it in mind that
Yeah.
potentially in the future, this could be turned into a duplex. All of the precedents that were shown and that exist in this neighborhood are actually developers' constructions that are turned around within a year, and they're doing for profit. These are not our neighbors. These are not people who buy the property and live there for good. So this is also something to keep in mind, that the development in our neighborhood is rampant. I think one of the reasons is because there is no limit to the amount of stories, unlike in many other neighborhoods of Toronto. So somebody can potentially
Okay,
build
can
a
you please,
five-story
can you wrap
building,
up? Thanks.
with the as long as it keeps to that, when it pushes the variance of the height. So the main thing is that the FSI, together with the height of the walls and length of the house, and also the proximity, because it uses the effect of this being so-called addition, the distance from this proposed house to the house to the north is only 75 centimeters. We're building something that is looming 30 meters above the grade in the rear, in the proximity of 75 centimeters between the two different buildings. This, together with the hilly nature of this neighborhood, I think it's just too much. And this is what should be really taken into consideration, the context of this particular
Okay, thank you.
property
Can you wrap up,
with
please?
regards to the previous precedents and the variances that they are pushing for, which are pretty much all of them.
Thank you. Next speaker is, again, Mr. Singh from the Ratepayers Association, the Swansea Ratepayers Association.
Yes, hello.
Welcome again.
Let's see. Thank you. I think there's enough community representation to withdraw our request for a postponement here.
Right.
Yeah, the association recognizes that a development at this address is desirable, but this building doesn't fit the surrounding context, in our opinion, and it doesn't meet the four tests. Major difference between this location and others is, as mentioned, the hill that it's on, and it's amongst much smaller homes. Sometimes a hill can justify variances, but in this case, it works against it. The addresses that were referred to earlier, 1315 being down in the valley, are assisted because they're lower down and don't loom over the rest of the houses in the neighborhood, whereas this one being on a hill is in a different location. So it was quite right to point out that the previous approvals don't set a precedent, and it's important to keep that in mind when looking at this one. The design, if you look at page 2.1, really A2.1 of the plans proposed presents the problem in pretty stark terms.
Mr. Singh, your voice is trailing off. Can you please try to project a little better? We've been listening a long time, and it's hard to listen when it's so low. Thank you.
I will try, yes. Let's see if this helps at all. Okay. So, yes, again, the coverage, allowing a 1x coverage in a 0.6 zone eventually breaks down the zoning. So our 0.6 now becomes a 1x coverage. It's disruptive to the established character of the neighborhood. It's not desirable, and it fails to maintain the intent of the official plan. The intent, of course, is to maintain the zoning process that we have. I think that you have enough representation from the community to impress upon you that this is not characteristic of the neighborhood, the way this building is presented, despite if you're going to have balconies to break up the height. What we're talking about is a main wall where the bylaws have just been looked at. It's been implemented, bylaw 569/2013. Recently, the wall heights have been implemented there, and they have been deemed to be good planning for the protection of stable neighborhoods. As far as the parking space goes, at 2.5 meters, you're not going to park anything there. So in effect, there is no parking spot being presented here. We believe this proposal doesn't fit this location, and it should be refused. A more desirable design should be resubmitted for this location. So thank you.
Okay, thank you, Mr. Singh. Last speaker, Darren Elliott of 4 DURIE, and we have your letter. Welcome. Mr. Elliott there? And we have the letter, various letters here of objection. There's a lot of them. So again, if we can't reach Daryl Elliott, we'll have to go back to the agent. Seems like we spoke to her a long time ago, to go back and respond to the concerns that have been raised.
Yes, thank you. So I'm just going to address a couple of comments. The first, Mr. Gordon is concerned about constructing the addition. So I would like to put his mind at rest to some extent because we are retaining the existing foundation on his side of the home. So the only digging that we'll be doing will be for the new addition at the back or the rear addition, which is 15 feet. It will not be the entire side of his house excavated, just the 15 feet behind the existing foundation. The speaker from 30 Beresford mentioned a few things. Again, the parking space seems to be an issue, but as I've said, it's an existing permitted front yard parking. The size is not changing. It's been that size forever since it's been there. People will have to satisfy themselves. The other issue is people make a big deal about developers. In fact, my client is intending to live in the home and her parents are intending to occupy the basement suite. So she is building this home for herself. Again, Mr. Singh mentioned the parking space is a legally permitted space. And I would argue, as I did previously, that there are lots of precedents. There's lots of buildings that have been built in this neighborhood that have had requested far higher variances than the ones that we're asking for FSI and for height. And I'll leave it at that.
Okay. Thank you. Any follow-up questions for either the agent, Ms. Beaumont, or any of the neighbors who we've heard from, or is someone ready to make a motion?
I am concerned with the height being completely out of context with everything else adjacent to it. Big towering 3-story building next to 2 1.5-story buildings. So if you remove the height, then that gets into the FSI. So I just can't look at this as minor or in keeping with the zoning bylaw or OP. So I recommend refusal.
Okay, motion for refusal. Mr. Palmer, do you have a seconder for that? Ms. Reddick, all in favor? Okay, I'm opposed, so it carries 3-1. The application is refused. Okay, next application, item number 16, 1984 Bloor Street West. This is an unopposed application. It's for a eating establishment not being a permitted use in an R zone. We have a covering letter and supporting materials and photos. And nothing from city staff or neighbors. Well, we do have supporting materials and a cover letter. That's right, okay. The agent is Robert Costello. Is Robert Costello there, please?
Yes, speaking, Chairman.
Okay, I don't think we need a presentation from you, sir. Why don't we just see if committee members have any questions for you? We have your supporting materials, your pictures, and your covering letter explaining what this application is all about.
Yes, of course.
Okay. Anyone have any questions for Mr. Costello, or are we ready for a motion?
Just curious, what's in the building currently? That it's in an R zone, but it appears to be in a commercial area. So I'm just curious.
Yes, we took over an abandoned space that was previously a real estate office, sandwiched and sharing walls with an assembly use restaurant and bar on one side and restaurant on the other. We're just the space that was a real estate office. We've reduced the floor space from approximately 60 persons to just under 30.
Okay. Sir, just a bit of a question. I see this is an Airden Burles application on behalf of a Ontario numbered company. The solicitor who we know well is Eileen Costello, and your name is Robert Costello. So are you with the applicant, or are you with our Airden Burles, or?
I am the applicant to the.
Oh, you're the
Eileen
principal
Costello
of the
is my-
numbered company.
I beg your pardon?
You're the principal of the numbered company 194-8628 Ontario Inc.
That's correct. Eileen Costello was my sister. She's representing.
Oh, okay, okay. Very good. Excellent lawyer. Okay, so does anyone else have any questions? Is just for an eating establishment not being permitted in our zone, and there doesn't seem to be any opposition to that. Someone ready to make a motion?
Making a motion to approve this application. I find the variants are minor in nature and consistent with the FOIA test.
Okay, thank you, Ms. Ruddick. Could we have a seconder for that motion? Ms. McCluskey, all in favor? Unanimous approval. Thank you.
Thank you,
Thank you,
Committee.
Mr. Costello. Thank you.
Thank you, sir.
Okay. Item number 17, 165 Quebec Street. It's an application to construct a new one-story front addition and a new front parking pad, and there are 8 variances. We have revised plans, cover letter. We are planning, refusing, suggesting, hold on a second. And again, we only have the agent, Antero Fonte, registered to speak on this application. We have a covering letter, supporting materials, planning and transportation comments and support. Let me just remember what the planning condition is. Oh yeah, they want, the community planning is recommending refusal of the variance relating to the front parking pad on this application. And transportation also objects to the proposed parking space. And there's 6 letters of support, 6, and opposition and concern. Okay, but all we have registered here is Mr. Fonte. Mr. Fonte. Antero Fonte?
Hello, can you hear me?
Yes.
Speaking, hello, good afternoon.
Yeah, can we get just explain to us what the situation is here? Planning is, first of all, are you in favor of, or are you in agreement that the refusal of the variance relating to the front parking pad? Community planning and transportation are not in favor of that.
I don't think that we had a variance related to the front parking pad. Did we?
Am I on the right application?
We had a variance.
This is COLBECK, right?
Yes,
This is
correct.
165 COLBECK.
Yes.
Okay, and I have a memo from community planning. COLBECK.
That's correct.
Community planning
165
recommend that the
COLBECK.
community refuse the variance related to front yard parking pad.
I don't think we have one of the listed variances. Number 7 is the rear yard soft landscape, and number 8 is the parking space at the rear. There is a note about the front yard parking, yes, and we have no objection that from that letter from planning.
Okay.
Or transportation. I can provide a little bit of history if I can.
Yes, go ahead, please.
The owners did contact a number of neighbors, and they obtained the letters of support from those neighbors. The immediate neighbor adjacent to the east is 161 COLBECK Street, and they were trying to obtain a letter of support from that neighbor. In that process, that they engage in a negotiation to revise one aspect of the proposal, and that's the dimension and projection of the front bay window. So the owners did engage and did accommodate the requests of the neighbor at 161 COLBECK Street, and that's what's reflected in the revised plans and elevations that were submitted recently. So those
But
revisions.
your plans show a very wide front yard parking pad.
And we do, but we were not aware of the rejection of transportation of that.
But planning is also recommending that not be approved. So that's what the chair was asking you about at the beginning, if you could address the front yard part.
It says here, by requesting variance for 0 parking supply on the lot, variance 8 relating to parking space dimension is not needed. The Committee of Adjustment does not have jurisdiction over the city boulevard, as that is under the purview of the city's Transportation Service Right-of-Way Management Division.
Fair enough. Specifically to the front yard parking, our initial proposal or our initial drawings to the zoning certificate, they included the back garage being demolished. Because that was not in accordance with the zoning bylaw, we've since retained the parking garage. So it's no longer proposed to be demolished. So in the notes that I sent to the committee last week or a couple of weeks ago, we are waiving and we are no longer seeking variances number 7 and number 8. So we still have the parking spot at the rear of the property.
Okay, so 7 and 8.
You're deleting variance 7 and 8, correct?
Yes, we are asking
Yes,
the
which
committee
is-
to consider.
And that's in
deleting
line
those,
with
yes.
the planning recommendation to not give the front yard parking variances. So we
That's
so far
correct.
are all on the same page. So now let's hear about,
Yeah.
we seem to have a lot of some concern and objections here. Have you reviewed those letters? And we don't have anyone present here to discuss it, but they did
so
send
we
in
had
letter. We
that-
do have these letters, so you are required to, consider that and as if they were here because they've written in a letter. So we have the
Yes,
people at 161 Colbeck.
That's correct. That's the one that I was talking about. That's
Mhm.
the neighbor adjacent to the east that the owners engaged with.
Yep.
And that there was some back and forth, and it focused specifically on the size, the width, and the projection of the bay window at the front of the house.
Okay.
The owners did accommodate the request of the neighbor at 165, and the plans that were revised and sent to the committee already reflect that. So the projection was reduced from 67 centimeters to 40 centimeters, and the width of the window was reduced from 4,700 millimeters to, I can give you that number very quickly, to 3,500 millimeters. So we feel that we accommodated the concerns of the next door neighbor into our proposal. And if the committee is willing to accept those revisions, we are willing to accept also the decision of the committee.
But what
Madam
other-
Secretary, we have revised plans here dated November the 4th, I believe.
Right, but
And
I'm
no-
not clear about what variances he's amending, and you can't speak in millimeters, you have to speak in meters. That's what your notice is based
Okay.
on in the zoning. So does
So-
variance
so-
1 change?
Does not. The only variances that change is variance number 4. It changes from 1.53 meters to 1.26 meters. And we're no longer seeking variances number 7 and number 8.
Yes, okay.
Okay.
Okay, so
These
variance 4
are
gets
the only
changed.
changes.
Okay, thank you. Okay, committee members, any further questions for Mr. Fonte, having reviewed the opposition letters? The people are not here, but their letters, have the same import as if they were. We have 7 and 8 eliminated, and we have a revision downward for variance number 4 that we've heard about. And so if there are any follow-up questions or if we're ready for a motion. Okay, so we have the new base window projection at 1.26. 7 and 8 are eliminated. And there is an urban forestry condition on this number 1. Someone ready to bring a motion?
Yeah, I'm prepared to bring a motion
you.
to approve this application. I find with the amendments as outlined in number 4, the reduction in the variance request for number 4 and the elimination of the variance requested for 7 and 8, subject to forestry condition number 1. Find that these variances are minor in nature and consistent with the 4 test.
Thank you, Ms. Ruddock. Seconder for Ms. Ruddock's motion.
I'll second.
Ms. McCluskey, all in favor? Unanimous approval. Thank you, Mr. Fonte.
Thank you. Have a good day.
Okay, we'll try. Item number 19. 18 has been deferred to December 10th at Toronto East York, so that was 52 right, if anyone's following along. And now we'll go to item number 19, which is the last item on our morning agenda, 1574 King Street West. Okay, and we only have one speaker, Jason Rodriguez, the agent on that application. Welcome, sir. This is an application to alter the
Good
three-story
afternoon,
semi.
Mr. Chairman, members of the committee.
Good morning.
My
I just
name
want to
is
just clarify
Jason
just what
Rodriguez.
we're
I'm from
doing here.
Inter-Arc, and I'm acting as agent on behalf of the property owners.
Yeah, thank you. Can I just summarize what we're here for? This was an application was previously before committee.
Correct.
And granted certain variances. There's one additional variance that was back in December 2014. And so we're here for one additional variance on this application, which is the floor area of secondary suites. And we have...
Correct.
Let's see what we have on this. Yeah, we just have the covering letter in the previous decision. So any questions for Mr. Rodriguez? Is someone ready to make a motion?
Do you require any background information?
I don't think, I just see if
Sure.
committee members have any questions for you, but this matter is before committee and approved in 2014. And there's just one additional variance dealing with the this situation when you have this size of the secondary units compared to the other units. So we only have the one variance. Does anyone wish any explanation from the agent? He's available if you do. And there are no conditions. So there is no construction proposed. The construction was back in 2000 pursuant to that approval, correct? There is no additional construction being proposed here. The one-story front addition, rear one-story addition, that was back.
Correct. There's no.
So there's nothing further being built.
Correct. There is no construction being contemplated under this application.
Right.
Correct. The variance is as a result of the city's new passing of the second suite bylaw.
Correct.
And the 45% is a new variance as a result of that. Now, a variance very similar to that was granted under the previous application, which varied the average unit size of 65 square meters.
Yeah. So it's interesting because you've already had this where you'd have to come back if they changed the bylaw, or it looks like the bylaw is 2013, your application was 2014. So in any event, you're here to clean this up.
Correct, but
clarify the situation
yes,
to get this variance.
The second suite bylaw was something that was amended to the 2013 bylaw, and it came into effect after the application was made, but also after the transition clause from the 2013 bylaw had lapsed. So because it's more restrictive, we require the relief.
Okay, so you're here to clean that up. So someone bring a motion, please. There's no objection to this.
Yeah, I move to approve the application. Consider it
One
meets the floor
variance.
test.
Thank you, Ms. McCluskey. Seconded by Ms. Roddick. All in favor? Have your approval unanimously. Thank you very much.
Thank you.
Okay, it is now 8 minutes to 3, and we are finished the morning agenda. So we stand adjourned until next week.
At the very least, 3:30. 3:30-ish. Sorry, everyone. We'll be with you in a moment.
All right, quick. I think it's like cold sweats. I don't know which.
Hi, so while we're breaking, I'm going to begin the sound check for the afternoon session. So Edward
Oh, I
Lee.
think it's. Oh, hold on a sec. Sorry.
Hey, Edward.
Oh yes, hi. Speaking. Sorry, I thought there was an adjournment until 3:30.
Yeah, we're just doing the sound check to make sure everyone's connected and stuff. But I'm gonna put you back on mute, and then we'll see you at 3:30. Okay?
Okay, great. Thank you.
Hi, Vera.
Hello? Yes.
Hi. I'm just doing a sound check just to check your connection. So I'm gonna put you back on mute, and we'll see you at 3:30. Okay?
Wait a second. Who's speaking? Is this Adam?
Yes, it is. How are you?
Well, I've been waiting since 12:30.
I know we've the morning session ran a little bit late. Well, a lot a bit late. We just finished now, so I apologize for the inconvenience. We're gonna start the afternoon session at about 3:30, unfortunately.
And can I see you on video?
You'll be able to see the council chambers on video. I don't know if you can see it now, but
Yes, I can.
That's what you'll be able to see on video with all the members, but they won't be able to see you. So, but they can hear you. They'll be able to hear you.
So I can't see you and you can't see me.
You'll be able to see the members.
No, I'm asking about you.
Oh, no, you won't be able to see me, no.
And I only see 3 people.
Yeah, you'll see 4 people sitting at the table. They've gone for lunch now, but you'll be able to see them when they come back.
Okay, thank you.
Okay, no problem. Hi, Nancy.
Hello.
Hi. You're here to speak to item
hear me?
20, 1084 Queen Street, right? Yep.
That's correct.
Okay, I'm going to put you back on mute. We'll see you in a little bit, all right?
All right, thank you.
Hi, Randy.
Yes.
Hi, how's it going?
Here.
So you're here for item 20 as well, right?
That's correct, yeah.
Okay, thank you.
Okay.
Hi, Sarouj.
Hello.
Hi, you're here for item 21, right? 62 Stanley Terrace?
Correct.
Okay, thank you.
Thanks.
Hi, Mark.
Hey, Adam.
Hi, you're here for 62 Stanley Terrace as well, correct?
Yep. Is the sound okay?
Yeah, you sound good. All right, I'm gonna put you back on mute, and we'll see you at 3:30.
Thanks.
No problem. Hi, is this Linda?
Yes.
Hi, I'm just checking the sound, but the sound seems like it's working, so I'm gonna put you back on mute, and we'll see you at 3:30. Okay?
Okay, thank you.
Hi, call in user 31 416 795. Call in user 31 with the phone number 416 795. Hi, Kamal. Sorry about that. I was trying to find your name.
Okay. I
Hi.
freaked out. Can you hear me okay?
Yeah, I can hear you okay. I'm going to put you back on mute and we'll see you at 3:30, okay?
Thank you. Thank you.
Hi, Jennifer.
Yes, this is Jennifer.
Hi, I'm just checking the sound.
Norman.
Sound seems like it's working. Yep, so I'm going to put you back on mute and we'll see you at 3:30, all right?
Thank you.
Not really. Not really.
Jeffrey Moot.
Yes, I'm here.
Okay, thank you.
Did you hear me okay?
Yep, we're good. Sasha Delgado.
Hi, I'm here.
Okay, thank you. David Smith.
Yeah,
Okay, thank you.
thanks a lot.
John Graham. Hello, John Graham. Scott McAvoy. Scott McAvoy. Edward Broders.
I'm here.
Thank you.
So busy.
Alexander Silva.
Yes, I'm here.
Thank you. Ronald for 201
Yes, I'm
Emerson.
here.
Okay, thank you.
Yeah, I'm here.
Evan for 420 Gladstone.
Hi, speaking. We've applied to defer. Do we have to wait around the rest of the afternoon, or are we free to go?
No, you'll have to ask for a deferral. I'll try to get you at the top.
Okay, great. Thank you very much.
Okay. Mike de Oliveira.
Hi, yes, I'm here. Thank you.
Okay, thank you. Argentio Siska.
Yes, I'm here.
Thank you. Shensu Zhang. Hello, Shensu Zhang. Ben G. Hello, Ben G. Oh. Antonella for Boone.
Here, hi Barb.
Thank you. You're just a little quiet, so if you can speak directly into your
Okay.
device after, thanks, that's better. Nafisa Zangyabadi for 17 Browning.
Yes, I'm here.
Thank you. Joel Leon.
I'm here.
Thank you. Sava for 23 Havelock.
Good afternoon.
Thank you. John Graham. John or Gail Graham.
Yes, here.
Okay, this is John. You'll be speaking.
No, I'm not planning to speak. I'm just listening.
Oh, you can do that on YouTube.
Oh, I don't have that link. Sorry.
Okay, that's fine. We'll just know. So we don't have to call on you, correct?
You don't have to call me, no.
Okay, thank you.
Yeah.
Scott McAvoy.
Yes, hi, I'm here.
Hi, I've got you here on 2 devices. This one seems to be working. Can you disconnect from the other one?
Yeah.
Okay, so don't disconnect from where you're speaking now, though, because it's perfect.
Great, thank you.
Thanks. Shenshu Zhang. Hello, Shenshu Zhang. Bin G. Hello, is Bin G there? Hi, Claire Sellers.
Yes, hello. Can you hear
Sorry,
me?
we had you as Patricia.
Yes, my first name is Patricia. And unfortunately, given the time overruns, you're not starting until 3:30.
Yeah.
I have to attend another board meeting. My assistant, Abina Morgan, will be representing me.
Sorry, what's her name?
Abina Morgan. My understanding is, however, that the applicants are seeking to seek adjournment. They've sent a letter to me to the South Rosedale Association indicating the same.
Okay,
So
I
is it
haven't seen that though. Okay, so Avina Morgan, Avina Morgan, will be speaking on your behalf?
Yes, she will be.
Okay, and will she be using this number or will she be calling in separate?
Yes. No, she will be online.
Okay,
This number.
thank you.
Thank you.
I haven't checked the color music.
Hi, call-in user 32 with the phone number 416824. Can you please identify yourself? Hi, call-in user 32 with the phone number 416824. Can you please identify yourself?
Hi, this is Evan Torrens. I'm just going to switch to my phone if possible.
Okay, no problem.
Great, thank you very much. I'll stay on the phone and I'm going to disconnect from my laptop.
Okay.
Thank you.
Bin G. Shen Shu Zhang.
Yes, I'm here.
Hi. You're here to speak to item 29, right?
Right.
Okay. I'm going to put you back on mute. Thank you.
Thanks.
Adrian. What's going on?
Hey, how's it going? Huh? And we fake everything else.
The room's muted. The room's muted.
I get them mixed up. I don't know. Okay. Oh, you. Oh, Jerome wasn't there. He was.
He wasn't there when I first came in, and Barb didn't answer.
Yeah.
Yeah, I did call you. Oh, okay.
39. You haven't even called the
I
cell.
need to program in your cell.
I got it. Yeah. If you saw it was me, he would have taken off.
Oh, so you're known. I still have to explain myself.
So let us know when you're ready to get. So we have to read the opening things again. Good afternoon. During the declared emergency in the City of Toronto, Committee of Adjustment virtual public hearings are being conducted by electronic means through WebEx, an online digital platform, and streamed on the Toronto City Planning YouTube channel. These measures are necessary to comply with physical distancing requirements and a provincial order that limits attendance at public gatherings. This will be a virtual public hearing, and participants who have registered in advance will be able to make their presentations to the committee using WebEx, an online event that is being moderated by city staff. Anyone wishing to view the hearing may do so by watching on YouTube. Participants who have registered in advance will be connecting either by their computer, a phone or tablet app, or by telephone. All participants will automatically be muted on entry. When your item is called, each participant will be unmuted by the moderator, one person at a time. Registered participants will be participating by audio only, and we ask that you mute your devices until you are called on to speak. Land acknowledgement. We acknowledge the land we are meeting on as the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. In accordance with Sections 45 and 53 of the Planning Act 1990 as amended, this meeting of the Committee of Adjustment of the City of Toronto is called to order. The Committee of Adjustment considers applications for variances from the provisions of the zoning bylaws that apply to the property, permissions to extend or alter lawfully non-conforming uses, and consent to sever property to create new lots. Anyone who wants to receive a copy of the decision of the committee on an application this afternoon must submit a written request for a decision by email. Please ensure that you include your name, address, and email address, because Committee of Adjustment and the TLAB, in the event of an appeal, will be sending notifications and appeal updates by email. If you do not agree with the decision of the committee rendered here today, decisions may be appealed to the Toronto Local Appeal Body, TLAB, or in some limited circumstances to the Local Planning Appeal Tribunal, LPAT. Appeal instructions are set out at the bottom of the decision of the committee. The hearing procedures as follows. We'll call each item in the order listed in the agenda. I believe we're going to start off just by dealing with one deferral matter. But otherwise, we'll start at item number 20 and go through to item number 33, which is the afternoon session. When an application is uncontested, the agent or application will only proceed with the presentation if requested and required, and the committee may ask questions or take the matter into committee for a decision. When applications are contested, the applicant or agent proceeds first, makes the presentation to the committee, and each speaker, including the applicant agent, will be given a maximum of 5 minutes to address the committee. And Mr. Palmer is watching the clock, and he will notify you when you're approaching the 5-minute mark. When addressing the committee, please state your name and address at the outset, and please remember to confine your remarks to the matters outlined in the application. Please note that the committee may not entertain revisions to proposals at the hearing today, especially since this is a Toronto East York hearing being conducted by Etobicoke York panel, as committee members are empowered to act in all divisions, but in the event of an appeal, it would go back to Toronto East York to be heard. So in the event of revisions, may have to be a deferral, and that is required in order to ensure that the revised application is accurate and that all those entitled to notice of the application are informed of the changes. Once the applicant has made a presentation to committee, individuals in support or most usually opposed to the application will be invited to speak if they registered to do so in advance. Committee members may ask questions of each speaker after they finish their presentation, and when all speakers are finished, the applicant or agent is given an opportunity to rebut only those issues that were raised by the speakers and to respond to any questions, but not to raise new matters or provide new evidence. Are there any of the committee members or staff have any declarations of interest to declare on the matters before us this afternoon? No? Okay. So I think we're going to first deal with, the first application we're going to deal with is item number 26, which is a, no, is it 26? Secretary, is it item number 26 we're going to deal with?
Yes, for 420
Okay, 420
Gladstone.
Gladstone. This is a deferral request by the applicant, and there's no one else appearing registered to speak on this, so.
I am here ready to speak on behalf of the homeowners.
Okay, so are you Evan Torrens?
That's right. I am Evan Torrens. I'm the agent representing the owners of 420 Gladstone.
Okay, so you're looking for a deferral of this application. This is to convert and alter the detached garage to an ancillary building. I believe this is what it was for, right?
Correct.
And okay, so what's the purpose for the? I think we have to note the purpose of the deferral request.
The purpose is we became aware that there were perhaps some inaccuracies in our representation in the drawings only after they're sent out to neighbors, and we became aware that they perhaps misunderstood our intentions and believed that we were trying to build a.
Right, I remember reading that, but what came back is not what you were looking for. So there's a disconnect there.
Correct. Yeah, we just want to make sure that we have time to make those revisions in the drawings and communicate that with our neighbors.
Okay. Very good. So motion to defer.
Motion to defer.
Thank you, Ms. Reddick.
26, 420 Gladstone Avenue.
Okay, and seconder for that motion?
I'll second.
Okay, all in favor? Okay, the matter is deferred. Thank you.
Thank you all very much.
Okay. So we're return to item number 20, which is 1084 Queen Street West. This is for an outdoor patio. We have supporting material, and we have planning has 3 conditions of approval. In the event of an approval, they're requesting 3 conditions. And the speaker on this application is Edward Lee.
Yes, I am here. Edward Lee, representing the owner.
Okay, we have 4 people registered to speak. I don't know if they're all in favor, all opposed, or some of both, but perhaps we'll find out. Let me just go there. Okay, so Mr. Lee, could you just briefly tell us, this is to
yes.
For an outdoor patio, I guess, for especially given have anything to do with COVID or challenges
well, the application
restaurants?
with actually, yes, I can skip all that stuff because it's very obvious. Everybody knows that hospitality industry is going through challenging times.
Yes.
And I don't exaggerate when I say this. This patio is literally life and death for this business, as outdoor dining has become the biggest lifeline for restaurants.
Right.
When the application was filed last year, I expected the opportunity to go through pre-circulation, which has always been a great opportunity to get early feedback from city staff. We were not put through pre-circulation, and the staff report, which you have before you, which was uploaded last week, only recommends the standard conditions, 3 conditions. We, of course, accept all of these conditions.
Okay.
To quickly clarify the minor variances, the setback from the rear property line to the residential lot is 5.3 meters, but the actual patio setback is 12.8 meters to the lot. And it's also worth mentioning that the existing grade at the rear of the property is such that the patio will actually be partially sunk down relative to the lane, which I believe will help a little bit to mitigate sound.
Okay.
These are the only minor variances we're requesting. The use of an outdoor patio and the size of the patio are both permitted by zoning. And I believe that by adopting the conditions recommended by planning, the outdoor patio does meet the 4 tests. And for a mixed-use area that encourages live, work, eating, and shopping all within the same block, I believe it is a desirable addition to the neighborhood, that it does meet the general intent of zoning bylaw and official plan. Having read the last-minute letters of objection that were filed, I do understand that to the neighbors, the numbers may not appear minor in nature.
Sorry, what? I don't have any. Do we have any letters? I don't have any letters. I just have people registered to speak. I don't know what they're going to speak about.
Okay, well, I'm quite certain that they also, there were a lot of late letters that were posted, so I believe that they're also waiting on the line. But just wanted to address that, while the number may appear not minor in nature, I do believe that it's reasonable based on the urban context of Queen West and similar patios that I've had approved on Queen Street and Ossington. And just to give some last minute updates, the restaurant had been reassured all through the summer that by patrons, which includes neighbors in the block, that patio would be a welcome addition, that it would give them more options for outdoor dining during COVID. They were able to get some verbal support from neighbors at 137 Dovercourt, 159 Lisgar, 1081 Queen Street, obviously all filed late. But we do want to acknowledge the 3 letters of objection that were filed. One of those 4 letters was a late mailing letter by the same neighbors.
Well,
So
they're not. It's not before us unless they're one of the people speaking. Do you have the address?
Okay, that's fine.
What's?
I think it was 115 Dovercourt.
Yeah, they were one of the people speaking.
Yes,
I actually want to see where they live. Anyway, let's hear from the neighbors, and I think especially in the COVID situation, patios are essential for survival of perhaps this and other restaurants. So I'd just like to hear what the concerns are. I've always found it interesting that people that buy a house and within spitting distance of a major street like Queen, and then come to committee and complain when someone wants to put in a use because they bought a house within very close radius to a major street. So let's hear what their concerns are. Okay, Mr. Palmer has a question for you, sir.
Sir, planning refers to a fence in Plan A01.
Yes.
What type of fence is that? Because all I see is it says existing fence on that plan. It doesn't say what it's made of, the height. Which I think may help.
Yes, absolutely. There was an existing wood batten fence there, but it will be rebuilt. So that will be, full visual and sound barrier privacy fence.
What height?
Could be 1.8 meters relative to the parking space, which actually would be 3 steps even higher than what would be required relative to the patio level. So you can see that there's 3 steps up from the patio to the parking area.
Yes. Okay,
so we would build a 1.8 meter fence relative to the parking space.
Okay, and is it just on the one side, and I can't tell what direction that is? Is that the south side?
So the fence that I was referring to is on
side?
the north side, but any fences that are existing on the east and west sides, we would be happy to rebuild. Essentially, we need a 1.8 meter fence all around the entire patio.
Okay. All right, that's great. Thank you.
Okay, Mr. Lisa, with your permission, let's hear from the neighbors. You'll have a chance to respond. First person registered to speak is Vera Frankel of 1088 Queen Street West. So a couple of 2 doors away.
Can you hear me?
Yes, can. Good afternoon.
Should I begin?
Yes.
there are so many problems that this situation has inflicted on the neighborhood that I'm not sure where to start, but I could begin.
Why don't you
very
begin with telling me
simply.
your address, your name for the record?
Well,
Just
my
the-
name is Vera Frankel, and I live at 1088 Queen Street West.
Okay, that's a residence. It's not a commercial building, or you live
It's a
above? Or,
residence. I've lived here for 20 years.
okay, ground floor and main floor?
Yeah, ground floor and upstairs.
Right, okay. And what are the other uses along Queen Street there? There's a restaurant, I don't know. So there's one property in between you and this property, or you're right next door? Is there a 1086?
There's a plant shop.
A plant shop
Yes.
in between you and this restaurant?
Yes.
What do you mean, like
It's
a flower shop?
plants, green plants.
Okay, green plants. Okay. And then there's this restaurant. And what's on the other side of you?
A bar. It used to be the Slavic Pentecostal Church, and then it became the Church Aperitivo Bar, and it's now called Bar Poet.
Okay, so you're living on, a retail strip on Queen Street, and you happen to be living there, and you're surrounded by restaurants, a plant shop, a bar, all kinds of, it's a diverse use. You have there's other residential buildings along there?
Yes, there are
Block.
residences in all these buildings.
Right, okay. So let us know what your concerns are. You said you didn't know, so now we started, we know where you are, we know what your use is and what the adjacent uses are, including this
And
restaurant.
who am I speaking with? Who am I speaking with?
You're speaking to, I'm Michael Clark, you're speaking at the Committee of Adjustment. I don't know if you're watching on YouTube as you're doing this. So you're appearing before the Committee of Adjustment now.
I'm watching on my computer, and you are the chair of the meeting, correct?
That's correct, yes ma'am. So why don't you tell us what the concerns are with the proposed patio being proposed for this restaurant at the rear of the property on Queen Street?
I live about 20 feet or 7 meters or so from the proposed patio. I've been a resident here for 20 years, as I've said.
Yep.
I was astonished by the building permit request being submitted after the patio was already built, and that the committee was asking for comments once it's operating. The whole situation is deeply concerning.
Okay, so we didn't know, so this is now in operation, it's already been built. When did that happen? Do you know when they started using it and when
I don't know exactly when, but it's functioning now.
I see. Okay, so pretty recently.
Yes.
Okay.
A patio right behind my living quarters and under my bedroom window means serious disruption. Can you hear me?
Yeah, what's happening at the rear of the plant shop? Do they have anything in the rear? Are they shipping, or so there's the plant shop between you and this restaurant and the patio proposed, the existing patio at the rear. There's one property between you, correct?
Yes.
Okay. And what's happening at the rear of that property? Do they do shipping from there?
I haven't observed. I assume so, but I haven't observed what they're doing.
So you haven't had any problems with that use?
No, they're delightful.
Okay, and what about the patio? Has the patio been causing you any problems?
Yes, starting with the construction, and then they have a very small snack menu with a very large licensing options.
I see. So it's mainly drinking and less food.
Yes.
Okay.
And I'm assuming there will be music, and they've just begun building a roof, which seems very strange. In general, they seem to ignore bylaws and assume that they will ask forgiveness afterwards.
Yeah, ma'am, just to let you know, the city planning is in favor of this, but they're asking for several conditions. They're saying that it would only be open from 9 a.m. to 10 p.m. No music, artificial or amplified sound being played or projected onto the patio area, and some details about the patio.
Thank you for saying that. But my experience with the bar next door is that the city regulations are not attended to. They're not. Can I finish my statement?
Sure.
Okay. A patio right behind my living quarters and under my bedroom window means serious disruption of the peaceful use of my premises and guarantees ongoing sleep deprivation. And given the current COVID-19 pandemic and those of us obliged to work at home, it also disturbs my ability to work. The city may be seeking ways to help restaurants and bars function during COVID-19, but the proposed and illegally acted upon variance is not minor. Its impact is major. My experience is also based on the fact that next door to me, a bar has been in constant disregard of the bylaws, and because of ongoing late night use of my front porch as a toilet or bedroom, leaving every kind of body fluid on my doorstep, I had to install a protective glass screen with the help of the BIA's facade improvement program. I'm still harassed by the drunken clientele and on one side, and I don't look forward to having that kind of harassment in stereo.
Yeah. Mrs. Frankel, is there a patio at the back of the bar as well?
There's a patio on, they just opened a patio on Dover Court. And it's an issue, thank you for asking, because that patio and its service disrupts the use of the sidewalk. And I use a walker. I've been in a train accident. I need a walker, and I can't get to my back door using the Dover Court sidewalk, which I normally would
Okay,
use.
anyway, that deals with the bar. We're not dealing with the bar. We're dealing with the restaurant here, so I don't think we need to
I'm
hear
not
about that.
finished my thought. In order to get to my back door, because I can't get past that particular patio, I would be blocked from getting to my back door by the other patio. I am talking about the other patio.
Okay. Okay, anything else?
Yes. Give me 1 minute. My only access, which is what I was trying to tell you when you interrupted me, my only access to my back door now is via Fennings, which is the entrance to the laneway where the patio is being proposed. And having to struggle past drinkers and serving staff with my walker is one more hazard to a situation that's already hazardous. And I know that patios are favored by the city at this time, although what outdoor dining will mean in the winter is yet to be seen. But I think you'll agree that disrupting the peaceful use of my home, not letting me sleep, is going to affect my health. And I think you will agree that adding to that, the clusters of these patio customers mostly do not wear masks, and being forced to be close to them is exposing me, and I'm in the age group that is susceptible. And we still don't know how the virus is transmitted. So walking close to an unmasked, shouting, laughing, coughing crowd is potentially disconcerting and dangerous. In short, my residential unit, my home for many years, would be trapped between two license units with licensing for, I'm told, up to 500 people together, a high concentration. And no safe access to my back door, ongoing noise and disruption. That's my statement.
Okay, thank you, Mrs. Frankel. Does anyone have any questions for Mrs. Frankel before we go into the next speaker? No? Okay. Next speaker is Kamal Bazin of 11A Dover Court Road, and it looks like you're just, from the location map, just on the other side of the laneway.
Yes, I'm on the residential street, Dover Court. My name is Kamal Bazin. I'm at 111A Dover Court. Mr. Clark, you mentioned that you wonder why people would purchase property so close to such a hustling and bustling part of town. And I would like to share with you that I live in a townhouse of 3 homes with a total combined time that we've been residents of 130 years. So, but with respect to my comment, I'd like to start by just sharing that as per Vera's comment, the restaurant we're talking about is actually called Bar Piquette. It is the name, their branding is Bar Piquette. It is indeed a very small tapas style menu, which I have tasted, and it's very, very good. But with a largely running as a bar, It's a very small restaurant owned by a very, very popular restaurateur, Grant Van Gameren, who also owns other restaurants across the city. He's often featured in media as a local celebrity chef, and including during COVID has written a number of articles that have been widely spread across the city's news outlets. And this restaurant pre-COVID was extremely popular within less than a year of operating, and didn't take reservations at the time, was open till 2 a.m. and frequently had a crowd gathering on the front end. Since COVID, as my neighbor Vera mentioned, prior to there being sort of formal rules set by the city to help support the sustainability of businesses, Bar Piquette was running their patio service. They played music. They since have stopped following the rules, but they did play music. The other thing that they did is advertise on social media that people can do sort of like, as many restaurants are doing, sort of like wine service and pickup and meal service and pickup, and they were also doing plants. Believe it or not, our neighborhood is popular for florists and plants purchases and purchase of plants. And in fact, on their social media, they asked that people access the alleyway, not Queen Street, but use the alleyway to park and pick up. The police were called, and they had to stop in the middle of the day that they were doing this sort of sale thingy that was set up in the back. And so in my view, while it is a busy neighborhood, like we're in the Trinity Bellwoods to Dufferin areas, like a hopping part of town, and it's great in many ways. Our particular strip, that is to say, the several streets and blocks right around us, do not have patios in the back. This would be the very first. This would be precedent setting. You four will set a precedent for our small section of the neighborhood. And what I'll say is that I'm very concerned about how the back alley is being used. I think increasingly we see drug use in the alley. I personally have seen crack use this past few weeks. The other thing that happens in a really popular neighborhood where there's a culture of restaurant use, which you may or may not know, is that restaurateurs invite their friends, the people closest to them to come, and actually they give backdoor access to their favorite people. So the front door is like people from the 905 and people coming into town to have a meal, but the back door is where your friends come in and where your neighbors come in. And so that is how our alley is used. And I'm very concerned about further setting the precedent. The last thing I'll say, just in closing, is that my house is a 5 to 10 second walk from that patio, like literally a 5-second walk if I'm in my backyard. And my backyard opens, my kitchen opens up onto the backyard. In the early days of the spring, when Bar Piquette was running its patio without permission and were playing music, not only did I hear the music in my kitchen, but when their patrons were laughing and enjoying themselves, which they have the right to do, but when they were doing that in the bar area in the back or in the patio area, not approved, I could hear that in my kitchen. And so while I agree that COVID it's difficult, and I really believe that we're all struggling, it's not just restaurants and it's not just businesses. We are also stuck at home and we are also struggling. And so I really impress upon you the precedent that you'll be setting here for our small block of homes. Thank you very much.
Okay, thank you, Ms. Bees. I just want to clarify, I didn't say why would anyone buy and live there. I said if someone buys and lives there on a mixed use eclectic street like Queen Street, and I'm even further west, further east where there's a lot more of that type of restaurants and bars or whatever, and I think that's your concern. I'm saying that when you do that and you're the first house off a laneway on the other side of a busy retail strip, that invariably that's going to be one of the things that you're going to have to experience. And you'd figure that you would have known that when you decide to live there off on a lane, the first house on a laneway, sort of a transition lots or two behind a major street. That's all I was saying. I wasn't saying why someone would want to live there. Just wanted to clarify that. So does anyone have any questions for Ms. Bazin before we move on to the next speaker? Okay, so next speaker is Nancy Ribeiro Christodoulou at 115 Dover Court. Nancy?
Hello.
Hello.
Yes, I'm here.
Welcome.
Hi, I live at 115 Dover Court, as you just mentioned, and I'd like to indicate that I've actually lived here my entire life. I've been here since 1970. So I predate the restaurant, which has only been in place for a year now.
You're having trouble hearing you, ma'am.
You're having trouble hearing me?
Are you speaking into the phone or get close? You get closer.
Can you hear me better now?
Yeah.
Okay.
Okay, so you've
My
lived
name
there.
is Nancy Christodoulou, as you've mentioned, and I've lived here, contrary to Mr. Lee's comments, since 1970. Now, that address, 1084 Queen Street West, was previously a party planner's shop until last year when it was converted into a bar. And despite the fact I'm 4 doors north of the premises, this patio has been built without permits and faces my backyard, and now they're requesting a patio license. From my backyard vantage point, the patio is a mere 60 feet away. The patio is already in place, appears to be designed to be a covered structure in future. This is not a temporary COVID build. I understand that in COVID, we need to make some allowances to allow businesses to survive, and I'm all for that. What I'm not for is setting a precedent that would allow this build that is existing to continue on post-COVID. My concerns are, first of all, you don't have my letter because I was only given one business day to respond to the notice. As such, I was advised my letter would not be provided to you in advance. We have existing issues with overcrowding of sidewalks and patrons that line up for bars and restaurants. I can't use the sidewalk on the southeast corner of Dover Court as it has been taken over as a service zone and too narrow for my children and I. So we always have to cross the street and cross back. The laneway is already overcrowded with delivery vehicles and people who often drink back there in the evenings. This will also increase the amount of garbage and rodent issues, especially large rats that are already running across all of our yards. The bylaws exist to provide a separation for residents. So this request is in no way minor, in my opinion. It would remove our enjoyment of our property. We already have noise from restaurants and their patrons, which line up to my neighbor's front yard. The noise is at all hours, but seems loudest from 11 p.m. to 2 a.m. It is an unreasonable request, as the bar is a small space which is trying to double its capacity with this request. It has a very small footprint. It wants to basically have the same footprint outdoors and have it enacted on a permanent basis. I would now like to read to you my letter. I'm writing as an area resident whose backyard faces the property at 1084 Queen Street West. We are separated by a narrow laneway. I would like to register my opposition to this request as it would impede the reasonable enjoyment of my home and backyard with the additional voices carried over the arid open spaces. My objection is based on the general intent and purpose of the city's zoning code and or bylaws, section 40.10.20.100, point brackets 21, bracket D. Bylaw 569.213, an outdoor patio must be set back at least 30 meters from a residential zone. The proposed patio will be located 12.8 meters from a lot in a residential zone, as well as section 8, bracket 2, 7, bracket I.
You don't have to give us all the bracket numbers, please. Just tell us what it says. Thank you.
Basically, the proposed patio will be located 5.3 meters from a lot in a residential district. Now, these bylaws were enacted to provide a much needed respite to the people in the abutting residential zones, which I understand based on Chair Michael Clark's comments, I'm not allowed to have this opinion because I've chosen to live here. But again, my existence here predates the restaurant. So why are my opinions not taken into account? Both bylaws are to provide a separation between businesses and residential properties to reduce overall noise intrusions from businesses which run into the early morning hours when people nearby are sleeping. As such, I don't believe the variance request is in any way minor at all, as it impacts on everyone's reasonable enjoyment, sleep, and ultimately mental health. This is a significant change that is being requested. It would be especially detrimental for people like me with young families who rely on the spacing and separation under the bylaws to ensure a peaceful night's sleep. The area and its proximity to Trinity Bellwoods has seen a spike in bar restaurants, places with a restaurant license, which predominantly serve small bites along with a robust list of alcoholic beverages. These establishments have created a surge in late night foot traffic on the street and in the laneways, which is loud, drunken, and unyielding.
Yeah, can
The
you please
noise
wrap
levels-
up because you're over 5 minutes, please? You're at 6 minutes. Thank you.
I basically would like to conclude with stating that I believe that the bylaws should be adhered to, that this temporary patio should not be made a permanent fixture.
Thank you. Okay, our next speaker, our last speaker is Randy Kerr from 18 Beaconsfield Avenue. Where does he live? Where's Beaconsfield? Adam, is he with us? Okay. Okay.
Hello?
Was that
Hello,
Randy
can you hear me?
Kerr?
Yeah, can you hear me?
Yes, we can.
Yeah, I had to switch off from my portable phone to my hands-free here, so I'll try to make it as brief as possible. Good afternoon to the chair and to the committee members. My name is Randy Kerr. I'm 18 Beaconsfield Avenue. I'm a member of the Beaconsfield Village Residents Association. I'm also civilian co-chair of the 14 Division CPLC, the Community Police Liaison Committee. So I'm aware of issues related to enforcement in this area.
Yep.
Have been for years. I oppose this application, the variances regarding the patio, and want to point out to the committee that when the city allows expanded uses like this, rear yard patios, example, adjacent to residential neighborhoods, it neglects to even have minimal changes to the city's services. Example, police, fire, ambulances, parking, garbage, by law enforcement. You never add to that. You just keep adding to laneway usage to allow a better coexistence with residents, pedestrians, visitors, vehicular traffic, etc. This results in a quality of life and safety issues and frustrations by the residents dealing with reporting incidents. Becomes unbelievable. Recent example, and this is personal, but part of our neighborhood. October 31st, neighbors were all Facebooking me about this construction noise going on our street. Continued for 6 hours. I reported it to the 311 noise bylaw infraction line. Saturday, October 31st in the afternoon. I received a call back on Friday, November 13th at supper time. 14 days later, clearly there is something wrong, and adding another potential site which will generate complaints doesn't make any sense. Planning staff made a recommendation November 9th, 2020, and although this application appears to have started back in February, no one from planning or the applicant reached out to the nearby residents. That's why I became involved. In fact, somebody at City Services should have been aware of the hundreds, and I'm talking about hundreds of complaints regarding 1090 Queen Street West, one of their neighbors, and denial of the application last year of their patio. I've dealt with dozens of these patio bar licenses, applications, etc. over the years and found the representations made by their agents, like Mr. Lee in this case, are sometimes meaningless once the establishment is a going concern. It falls back on the residents to complain because after the fact, it's left to us to complain and try to get some enforcement as to the bylaws that you're about to change. So, no patio, no license established.
So the one at 1090, was there an application at 1090 or did they just go ahead and start using a patio? That's the bar, right, that we heard about?
Sorry, say again?
The bar at 1090 in between this property or... Oh,
I'll give you a context for 1090. 1090 was refused a patio license by the community a year ago, before the COVID issues. It was refused. Politically, it went up the street. They had a majority of people denied it. So why doesn't the city staff aware of the sensitivity to patios to the residential neighborhood. It is a party central area from the standpoint that across the street from 1084 is the Great Hall, which has licensing for 2,000 people. So the fact that this little operation needs to have some additional licensing room in their back patio, interfering with the neighbors, is unbelievably, precocious, I guess is the best word, because anybody in our neighborhood that needs to get a drink can find a seat to get a drink. We don't need interruptions of lifestyle and people's enjoyment of their premises just because a bar owner purchased a building or purchased a establishment and wants to double the capacity. In this case, it would be a double capacity of their licensed establishment. We no longer even have the ability to go through the AGCO to show our displeasure with this type of activity. And so we're left now complaining to the COA because there's no other recourse before it gets approved. And once it's approved, believe me, there will be complaints about this. I've seen it from 15 other bar establishments that made the same type of representations to individuals like you that said, okay, everybody will behave nicely once they get going. No, they're in a competitive environment down here. It will be post, and it'll just be worse. They'll stay open till 11 or 12. There'll be music. There'll be people coming and going through the laneway, and there will be problems. So I've said my say. I'm getting very tired about these things, but we have to protect the neighborhood to some extent because it's if we don't, nobody else seems to do it. Okay, that's all I have.
Okay, just a question. So you said, was there a patio? You said there was a 1090, and you mentioned the noise complaints. Was that about the construction of this patio?
Oh, the noise complaints at 1090 were continuing to. They were operating an illegal patio. They were operating outside of normal business hours. They were having lineups of hundreds of people sometimes for special events. And as Vera said, people the laneways for backdoor access.
Yeah.
Meanwhile, everybody was blocking the street. You couldn't get on the streetcar at that corner because of the number of people out. This is going to add to the same.
And you said you feel that the mitigation efforts suggested by the city are not sufficient of privacy fence and no music and the hours of operation to 10 p.m. You don't. That doesn't cut it for you, right? That you feel.
Well, good question. If serious, one second. If they were serious about protecting the neighborhood, they would make the operators of any licensed patio outside have a round-the-clock video camera with audio. So when we file a 311 complaint, it gets dealt with 2 weeks later. At least there's evidence, or could be evidence, when the complaint occurred. Because it's 2 weeks is useless. It's ancient history. People don't even want to phone 311 now.
Obviously,
when these things occur.
2 weeks later.
2 weeks later, exactly. I've got all the incidents. If you need the detail, I'll send it to you by email. This is just the most recent one of dozens over the years.
Yep. Okay, thank you, sir. Thank you, Mr. Kerr. Does anyone have any questions for Mr. Kerr before we go back to Mr. Lee to answer the concerns of the neighborhood? Okay, Mr. Lee? Mr. Lee? Okay.
Hi, sorry, you just muted me now. Thank you for everyone's comments.
Yeah, so the fact that the neighbor, the issue is you need a variance because of these issues that invariably happen from restaurants and bars and use of outdoor patios. There's a requirement, notwithstanding that they're close to a commercial zone, that they have a 30-meter buffer. And if you could give that 30-meter buffer, you'd be in good shape. But you're only being able to give 12.8, and so they've registered their concern to that extra 18 meters that it's too close to the residential zone. So how do we justify, and we know it's COVID and everyone's trying to stay in business, but they do make a point, this is not a COVID bar, this is a COVID patio, this is a permanent patio that they may have applied for even before COVID. So how do you answer these concerns for the variance? Remember, we're dealing with the variance here. If they were you're 30 meters away, no issue.
Yes, I sympathize with that, and I'm all about following the rules. I'm sure committee members are aware that very few restaurants downtown are within 30 meters of most are within 30 meters of a residential zone, which is why most patio applications do end up before the committee ever since the new citywide bylaw came into effect. It's unfortunate that everyone is focusing on 1090 Queen Street. I'm aware of Bar Poet, very popular bar, has a very large capacity right at the corner of Dovercourt and Queen. I believe the patio everyone is referring to is the Dovercourt patio that does take up part of the sidewalk. And I've walked around, I live in the neighborhood too, and I've gone for walks at night, and it is a rowdy patio, and I'm not surprised that many complaints have been filed against this establishment. Our restaurant at 1084 Queen Street is 30-seat restaurant. That was the maximum that we were permitted, being in a 3-story building. And the patio capacity is really to allow the indoor seating capacity to be moved outside, which is standard practice for city. And, you're never going to have a situation you're going to have 60 people inside just because the patio has been approved for 30 seats. I can't speak to whether the owners have been operating the bar. I know at the beginning when COVID happened, and it was kind of the Wild West of rules, before the actual Cafe TO program got implemented, everyone was doing what they had to do to survive. And I'm sure the neighbors all sympathize with that. And I understand that their concerns are about the future, in a day when we're no longer dealing with COVID. Will this be a long lasting thing that they're going to have to deal with? Characterizing the restaurant is, it's not Bar Poet. It is, a higher end, wine bar with tapas food. And yes, it's very popular. It's not the kind of place that has hundreds of people lining up to get into a nightclub like Bar Poet. It's a small establishment, and it will always remain a small establishment. The owners are listening to the YouTube channel. They have heard everyone's concerns. Obviously, there were no real rules in place during, the summer and Cafe TO. But them sticking to this application, which was made at the start of COVID, shows that they're obviously committed to, following the conditions that are recommended by planning, should the committee grant approval of the patio, and understand that, they're going to be scrutinized, and that operating a minute beyond 10 p.m., any amplified music or sounds, residents have every right to call 311, and I'm all for better enforcement of these complaint calls. And I understand everyone's frustrations that, the city is slow to respond, but all I can say is that, they will be held accountable, and anytime that official complaints are made against an establishment, the councillor's office is taking note of that. And, these are all black marks that are placed against business. So, the bar owners have nothing to gain by flirting the rules and being disrespectful to the neighborhood, especially should this patio be approved. They will have to be on best behavior. I was actually prepared to offer, I'm not sure if committee can actually consider this, but I have been the applicant for many patios, and committee staff have sometimes applied a conditional term to patio. This was not raised as one of the conditions for this application, because I do believe that the setback is reasonable relative to other patios that either exist as grandfathered in status or that I have had approved in the past on Ossington and Dundas, for example. So I think at the end of the day, the most important thing is to just reassure everyone that, if this would be approved, that it would be very official, and that the grounds for operation and respect to neighbors is something that I believe will actually help ensure that the restaurant does not disrupt the livelihoods of residential neighbors who happen to live directly behind the laneway. Obviously, anybody who lives on Queen Street can't necessarily speak to the actual minor variances that we're requesting, because they are relative to residential zone setback, not to CR zone setback. But I think, the important thing to remember is that the type of establishments really is what creates the character of Queen Street. And I do believe that this establishment will help improve the tidiness of Queen Street. And small businesses like this, once they fold because of COVID, because they can't, deal with restrictions on indoor dining, are going to get replaced by big chain, big chain shops, and the culture of Queen Street will suffer in the long run. So I think anything that can be done to help them survive, even if it is short term, I think.
Okay.
Yeah, that's everything.
You had 5 minutes. So interesting. You make that comment about the time limited, because I was surprised not to see that. And sometimes that's because it costs a lot to build a patio. So that wouldn't be. Now, did we hear that this patio has already been built and in use?
So I can comment on that. I advised them to not, risk their chances at the hearing, that they would, have to operate on their own risk. They were trying to do everything they could to survive. And, their hope is that this will be approved, and that even if it is on a conditional term, they're going to do everything they can to survive to even make it to the next committee hearing. And
Okay, so
we'll make it a goal to make sure they're on best behavior, so that if we are before you again,
that's why I'm thinking your suggestion of a time limit approval, say of 3 years, would make them be on their best behavior, would be able to show the neighborhood in the event that the committee would prove that for 3 years, that anything they did, that they would have to show that they're a higher end wine bar and tapas bar and not the same situation as 1090. And if not, the neighbors would be able to show up in 3 years and say, present their case to the then committee that it hasn't been a good experiment. Normally, maybe the reason wasn't there is that it's going to cost hundreds of thousands of dollars. Sometimes we've seen that the renovation or the cost would, the applicant wouldn't do it because there's too much cost for only a potentially 3-year return. But if they've already done it or done part of it, then perhaps that wouldn't be that objection, and maybe a good compromise is, as you suggested, and sometimes community planning puts in their conditions, it would be for a 3-year time limit.
It's a risk that they were willing to take by going ahead and building the enclosure, the roof canopy that the neighbors have pointed out.
Okay, so let's bring this into committee now and see if the members want to bring a motion of either approval, refusal, or a time-limited approval. And obviously, the neighbors and Mr. Lee are available for any follow-up questions that anyone may have before doing so.
I think the planning department and the applicant have heard the concerns of the residents. I'm prepared to recommend approval. Variance requested appears minor in nature, meeting the 4 tests of the Planning Act. With the conditions from planning regarding the hours of operation, music, and the fencing, 1.8 meter wood fencing all around the perimeter, and subject to a 3-year limitation, I guess, what's today, the 17th of November? Yeah. That's my motion.
Okay, thank you, Mr. Palmer. Do we have a seconder for Mr. Palmer's motion? Ms. Reddick, all in favor? Unanimous approval for patio on a temporary basis of 3 years, and I guess everything's good. Client comes back and gets to make that either permanent or for a further time limit. And hopefully that'll keep everyone, or this particular restaurant, retail community member, respectful of their neighbors in the residential zone behind. Thank you. Okay, our next application is another contested application, 62 Stanley Terrace. Or did I miss something? 21? How come 21 says Browning Avenue? Oh, okay, so I got to go to the next one. Okay. There we go. Okay, 62 Stanley Terrace.
Hello.
Yes, sir. You want to just hang on for 1 second, sir?
Sure.
This is an application to construct a 3-story north side addition, which will contain a carport and 2-story addition above the existing dwelling. There are 3 variances. We have 14 letters of opposition. Urban Forestry is requesting condition number 2. And what else do we have? That's it. Yeah, and they're seeking to, the one variance is seeking to go to 1.75 times coverage from 1 times coverage. And so my question would be at the outset of what your current floor space index is prior to construction. And we have registered Mr. Kalustian as agent.
Yes, hello.
Hello, sir.
Hi. Would you like me to answer the question in terms of the
Well, first just tell me that, and then you have,
GFA, or-
if you can make a brief presentation to the committee.
Okay.
Yeah.
All right. So, hello, Chair Committee. My name is Saruj. So I'm the applicant for the project. I would like to start off by explaining the existing site. We currently have a 1.5-story single-family detached dwelling with a GFA of roughly 0.7 around there. The current dwelling has 0-meter setback from the south property line and an enclosed porch on the east property line that results in a 0 setback as well. So what we are essentially proposing is addition above, as you mentioned, the existing dwelling and going above the existing parking pad, turning it into a carport. This proposal essentially results in the 3 variances that we have in front of us today, of which the south setback variance, as mentioned, is a result of the existing condition in the setback. The second variance, which is a setback on the east, is actually an improved condition of the existing. And the third variance is the GFA variance, which, to be honest, does not set any new precedent in the area. There are multiple dwellings on Stanley and in the immediate area that have a similar, or in fact exceeding, the GFA that we have in front of us. So to be honest, from the very beginning and during our schematic design stage, we have been in touch with the city to make sure we do not set any new precedent in the area and to maintain the general intent and character of the neighborhood. And as you can see, planning staff has no objection to our proposal today. And to give you some perspective of the neighborhood and current developments, majority of the development are single-family dwellings, which are immediately circling Stanley Park. Some are 3-story semi-detaches with 0 setbacks on all 3 sides of the property and no parking accommodation and a GFA of roughly 1.8 times the area. These are, for example, 52 Stanley and 54 Stanley. There's also 3 full-story townhouses of almost, again, about 1.8 times the area towards the south end of Stanley, and you can, those addresses are 44 to 50. There's also a 5-story apartment building on the north end of the park, and also on the southwest of the park, there are multiple multi-level condominiums overlooking the park. And looking at all this from the very beginning, I personally am convinced that these variances are truly minor in nature, and the proposal respects the physical characteristics of the neighborhood. So I'll be more than happy to answer any questions.
Okay, anyone have any questions for Mr. Kalustian before we go over to the neighbors? And the neighbors appear to be all directly behind at 41, 43, and 47 Stafford Street. 45 isn't here, but you got 41, 43, and 47. And we have, like I said, 14 letters of opposition with petition attached and signatures. So we have, you know, a lot more we have a lot more letters, but 3 people registered to speak today. So we'll hear from the first one, Mark Gatto at 43 Stafford Street.
Hi, can you hear me okay?
Yes, sir.
Great. First, I just want to say thanks for this opportunity to speak. I know you've had a long day already, so I appreciate it. My name is Mark Gatto, and I live at 43 Stafford Street, which is directly south of 62 Stanley Terrace. Yep. And I'm here today to oppose their application. Now, based on the 4 tests of appropriate development, this application is not minor in nature. It's not an appropriate or desirable development in keeping with the character of this neighborhood, and it does not keep with the purpose and intent of the zoning bylaw. But more than anything, what was so disappointing about all this was the fact that the owners of 62 Stanley Terrace made absolutely no formal attempt or effort to communicate their plans with us. You know, we would have absolutely welcomed the opportunity to have that conversation to see how this development might impact us, but the whole process was lost because they didn't let us know. And frankly, I have to ask the question, does this approach of not sharing construction plans really make sense to this community? So the communication was a huge issue for us, and I guess that's partially why there are 14 letters of opposition and no letters of support. So my other issue is we have concerns about our privacy related to overlook and the side yard setback variance. And because they're proposing to build 0 meters from the side lot line, and they're trying to almost double the maximum allowable density, they're essentially building right on top of the back half of our property, which also includes a rooftop terrace that will allow them to look directly down on our backyard and stare straight into the spare bedroom office space at the back of our house. And in addition to this, we noticed at the back of the house, in their plans, you can see it, they have a wall-length dining room set of windows at the very back of their house, which sit only a couple meters from our property and is slightly elevated. So they'll actually be able to look down in our backyard from an elevated position. And why this is a concern is that our backyard is a very private and well-used space, and we really rely on it to connect with nature. I mean, it's incredibly important for our mental health. And for us, upholding this 0.45 meter side lot setback requirement is so important. And then lastly, we're concerned we have a mature Japanese maple tree that sits only 3 feet from the property line, right where they are proposing to dig down another floor, which unfortunately will surely affect the root system and health of this tree. So just to conclude, we don't believe this proposed development conforms to the 4 tests. And frankly, we don't actually feel bad opposing this project because that essential neighborly communication process from the owners was non-existent. So I want to say thank you, and I really appreciate your time today.
Thank you. Anyone have any questions for Mr. Gatto before we move on? Okay, so there was no consultation. I don't know if this is an existing owner or a new owner. We'll hear from the agent on in his rebuttal, I take it. So we have the next speaker is Linda Nanku at 47 Stratford.
Hi, thank you for the opportunity. So my name is Linda Nanku, and I'm at 47 Stafford Street, which shares the north fence with 62 Stanley Terrace. We've lived in our house for about 46 years, and my mom is a disabled senior, and she relies on her gardening every year for the past 46 years. And that gardening relies on the sunlight that will come into our backyard. The majority of our backyard is gardening, which we use the crops every year, and it sustains us until about February or March, until she's able to plant again. The new proposed addition that they want to do on the north side will block the garden. It doesn't show on the drawing that we have a garden on the north fence, but we rely on that garden all the time. We're also a large family. We use our backyard a lot, and we rely on the privacy of our backyard. And what they're proposing to build will make sure that we don't see any of the trees. We'll see a lot more of the neighbors over there. Now, we've been friends with the neighbors that have lived there previously for the past 46 years. The recent neighbor that recently moved out was there for about 20-something years, and they were like family to us. So we were really disappointed when no one reached out to us to let us know that they were going to build this type of a structure. I would have liked to have a sit down and talk about what we would like to see and how it would impact us, just that neighborly feel. I also wanted to say that I did submit a letter with a lot of my comments on why I oppose the new build, and I wanted to just reiterate that not only will we lose the sunlight coming into our backyard, but we'll also lose the privacy, and we feel that the height that they're going up is far too high. And I'm not, we also want to have a good neighborly feeling in our property. we've always invited neighbors to our property, and we live like a family, on this street. If you've known how, if you can see, like people come to our street and they know who we are. And I feel really that these builders should have reached out to us. Aside from that, I also wanted to say that our bedrooms on the second floor looks past that house into Stanley Park, where I'm able to see my kids playing in the park itself. And when they put up that new 3-story addition on the carport, we won't be able to do that anymore. We won't be able to see the trees. We won't be able to see the parts of the park. And this is another reason why I oppose it. So, thank you.
Thank you very much. Does anyone have any questions for Ms. Nanku before we go over to the final speaker, Jennifer Norman at 41? Okay. Jennifer Norman, 41 Stratford, and we have your letter in front of us here.
Hello?
Hello, is that Jennifer Norman?
Yes, hello, can you hear me? This is
Yes.
Jennifer Norman of 41
Yes.
Stafford Street. Hello.
I
So yes, I
I
submitted
just
a
had your
letter.
letter, your husband's letter up here. I just lost it again, but why don't you just summarize your concerns?
Hopefully you'll get it back so you can look at it.
Yeah, no, there's a lot of them to go through, so I was looking at it, and now I
Sure,
just flipped to
sure.
some other ones.
Okay.
A lot of
Great.
14 neighbors have weighed in here.
Right. And to add to this, I am friends with Linda Nanku at 47, and we've been friends. Our kids have grown up on the street together. It is quite a wonderful neighborhood. My husband and I, our family have lived at 41 Stafford for 29 years. And we were friends with the previous owners who the new owners took over in January of this year. So I also express a concern that no consultation regarding their plans for the renovation and addition of stories and the whole design, no consultation was made to us at all. And we had very little time for notice of their plans. Anyway, so that was a concern, and there was a lot of scrambling to make sure that we could get this information and understand what the proposal was in a very short period of time. So in my letter, first of all, Linda and I did survey with other neighbors on our street, on Stafford Street, and we both submitted together signatures in supporting our opposal of this at 62 Stanley Terrace. So there, in addition to my name and my husband's on this, there are 13 other names on the opposed signature page.
Yep, we have that in front of us.
So one of the main points I want to make, not only how it affects us at 41 Stafford. First of all, the height, and with windows facing the rear, our backyard, we have a tree at the back as well that we have protected, and we back onto Stanley Terrace, our whole backyard. The proposed windows facing the rear of Stanley Terrace, going up 2 stories and further, they would be able to look directly into our second floor bedroom as well as our kitchen at the back of our property, as well as into our backyard. We're only 1 house south of the property at 62 Stanley Terrace. But the thing that is of concern on behalf of the rest of my neighbors is I've included that the windows that would be on these 2 extra stories would also impede the privacy of my other neighbors, right from possibly number 39 all the way to number 53, which are the properties behind Stanley Terrace. And the design has been not taking into any consideration the privacy of our neighbors and this whole block. And these residents have been, many of them have lived there for quite a number of years. And we are all friends, I would say, pretty much everybody. We all know each other and raise our families here, have backyards. So, and there are north-facing windows on proposed on the 2 stories as well. So that's why the privacy issue extends as well up to at least number 53. So it's like 39, 41, 43, 45, 45 and a half, 47, 49, 51, and at least 53, with those north-facing and west-facing windows up a couple of stories into people's homes, on their second level of their homes, first level of their homes, and into their backyards. So I feel that there is quite a severe privacy issue here, which
Hey,
was,
ma'am, can
there
you
was
try to
no
wrap up, please?
consultation or, okay. So that's the main concern. I also have an issue with the height and blockage of light and, yes, which was not existing before. It was also kind of unclear, the proposal, you know, I guess the house that exists now is considered 1.5 stories. There is a second floor with bedrooms, and it was unclear in the proposal, it's building from the height that it is already at 1.5, so that's almost like 4 stories. So there was a bit of confusion into how high this actually is, and, you know, is it a 3-story or a 4-story?
Okay, perhaps the applicant can answer
So,
that in his rebuttal, but there is no height variance. It's
okay,
a floor space
okay,
index, but perhaps we
sure,
can get that
sure.
information as to how many, because
Can
I
I
see a
just
lot of talk
continue
about
the
how many
other
floors
points
this
that I
is.
have?
I said that perhaps the applicant in his rebuttal will answer those questions.
Oh,
But if you could just wrap up,
sure,
please, because
okay.
you're
I will. I will. I just, other points that I made, which I'm of concern of, are with the basement sub-level patio, that they need to dig down to create, need supporting walls. And there are trees on the property lines, including at 43, 45, 45 and a half, and 47 around the property lines, which could be damaged or destroyed.
Yeah, ma'am,
And
urban
I wasn't
forestry
sure
has a
that the
condition
proper
here for variance number 2, but can you please wrap up because you've gone over time. It is now, and we've spent too
okay.
much time on this application, so I have
So,
to ask you
oh,
to please wrap up your comments. Thank you.
sure. So yes, you know, it's clear that we are opposing the proposal for 62 Stanley Terrace, that you will really, the committee will consider how this is affecting many neighbors in behind the proposal of 62 Stanley Terrace and the enjoyment of their home and their privacy.
Mr. Kalustian, you've heard a lot of concerns from the neighbors here. We've heard that there's been no consultation. I'd like to ask why you and your client did not confer with the neighbors as a new homeowner on the street seeking to do a major renovation and did not, which left your neighbors scrambling because of the tight time restrictions between the time they get receive notice and they have to get their comments in, especially during COVID. So can you please answer those concerns? So you're at 1.76 times the coverage of the lot. And we'd like to just also hear exactly how many stories. Everyone's confused as to how many floors there is. I note there is no height variance. So if you can please take 5 minutes to respond to those concerns and go ahead.
Sure. Well, I was informed by my client actually that during the schematic stage, he did approach 1 or 2 of the neighbors. I think they were immediately behind him. And they were aware of the proposal at that time. But in terms of once we got a number of substantial letters on Friday, of opposing neighbors. I did send out an email, a mass email to everyone, giving them an opportunity to call me to further clarify if they need any clarification or to answer some of their questions. But only one of the neighbors did. So in terms of consultation, as far as I'm aware, my neighbor didn't approach everybody in the neighborhood, but he did have communication with two of his neighbors. Now, we're aware of, in terms of trees and some of the comments there, we're aware of urban forestry's condition, and we're planning on making an application. Now, there's some other issues that came up in terms of, obviously, there's no variance on height. There's no variance on the number of floors. What we have on paper on our drawings are, in fact, 3 stories plus an area to go up to a small sort of terrace-like area that doesn't trigger any variances, but that's mainly to put the AC unit and a generator. That's the intention as shown on the drawings. I mean, some of the concerns about the privacy from that terrace, we're more than happy to propose a privacy screening. It's facing the rear yards, so people don't have that issue. There was a comment from Mark about the window from the dining room privacy. There is a privacy fence that's going to be put in back at 6 feet height, and that dining room is actually on grade level. And we got another, in terms of addressing the privacy issues, Jennifer was mentioning about seeing windows into her property, but we don't have any windows that actually face the south side into her property. So there, I mean, in all honesty, I can go on, but I know we're short on time. I just want to reinstate the fact that these variances are in fact minor. We're not setting any new precedents. Planning staff is aware of it from the very beginning and has no objections to the proposal. And there are precedences on the street for the GFA with more, and in fact, not even accommodating parking. The height, obviously, the carport was something that was important to put in, taking into consideration of the car situations around the park. We do not want to increase traffic, and we would prefer having our cars parked on the lot. And there are other properties that haven't accommodated that, and that's been approved by the committee in the past. So honestly, I can just wrap it up there. If you guys have any further questions, I'd be more than happy.
Well, sir, wouldn't mind on my question. I guess the major issue here, and you're right, there's no height variance, but you're at 1.76, where 1 point times coverage, which is one of the most generous zoning as of right in the city at 1 times coverage, and you're 0.76 above that. So where are you mentioned something about this is a common situation. Where can you give us some addresses on this street on?
Yes.
On Stanley, in the vicinity, and specific addresses with GFAs in that range.
Well, right on Stanley, there's 52 Stanley and 54 Stanley that have a GFA of about 1.8 times.
Is that a similar property? Is it a townhouse? Is it a similar property?
It's a semi-detached. It's a semi-detached.
It's a semi, okay.
Yeah. And then there's 44 to 50, which are full 3-story townhouse. And if you take them each lot, they're about 1.8 times the area.
Okay. Anyone have any questions for the agent? Any further questions, and someone ready to make a motion?
peers were all contemplating. So I'm not convinced that that this proposal is desirable development. I'm not aware that the proposals are minor in nature, and I don't believe that they are. I'm not convinced that they meet the intent and purpose of the official plan and the zoning bylaw. So I'd move a motion to reject this application.
Thank you, Ms. Reddick. Do I have a seconder for that motion? If there's no seconder for that motion fails, and I need another motion.
I'm struggling because some of the other cases that the applicant gave, for instance, 52, it looks like it's a multi-unit, residence, and this is a single family or a single unit, right?
Yep.
Yeah. I'm struggling with this one.
That was just an observation.
Yeah, sorry, just, yeah.
So
as I
you're
look
right,
on the,
like we didn't, at the beginning, like if it's different built form, is it really a precedent for that? If it's a semi or a townhouse or a semi, this is a single and you're seeking to
yeah.
Increase the coverage. There's a lot of opposition. There wasn't a great deal of discussion or indication of a number of properties that could be relied upon similar to this. And obviously it's the neighbors in the rear that are feeling most aggrieved, and a lot of them coming forward today, and then the other ones along Stanley who are in objection as well. We have 14 letters. Community planning has not weighed in, which is interesting. So we did have a motion to refuse, and that was not seconded by the other two members. So we need another motion.
Okay, I think we have a unique situation here, given the lot size. You can't really do much with it, so I think the applicant's tried to work with what he has and has come up with a solution. Maybe not the most desirable, but it's what's before us. So looking at it and recognizing the observations from the neighbors, I'm going to move for approval. It's minor, it meets the intent of the official plan and zoning bylaw. It's desirable and appropriate development.
And that would include
subject
variance
to-
number urban forestry?
Yeah, subject to the forestry tree permit.
Okay, is there a seconder for that motion?
I will second, but the applicant did mention the potential of a privacy fence, I think on the top terrace. So can that be added as an additional condition?
Okay, and the standard word on the two sides, opaque screening 1.5 meters, other applications,
Yeah.
conditions, so that would be added as a condition. Friendly amendment?
There is no variance for,
Right, but he did offer it as a
Courtesy.
as a
okay. so-
mitigating factor to the privacy that this property is going to. He did say he would put up
So you want
screening
the
on the deck?
privacy?
Privacy screening is the concern of, sorry, I forget the neighbor's name, but looking
on
onto
which
their
floor and on
bedroom.
which side?
I'll have to confirm with the applicant, sorry.
This would be on the two sides
Yeah,
of the, where's the
on the terrace,
upper
yeah.
level.
Yeah.
Mr. Kalustine, can you assist with that? If we had on the fourth floor, third or fourth, with the highest balcony in the rear? It's in the rear, correct?
I believe so, yes.
Yes, I did offer to put up a privacy screening towards the back end, overlooking the rear properties.
So is it privacy screening along the two sides of the rear terrace on which floor?
Well, in all honesty, the actual
I just need to
terrace
know
that
what
we're
floor you were talking about.
the highest floor where the terrace is.
But what floor is that? I need it as a condition. Is it the third floor,
Well-
fourth floor?
It's let's call it the fourth floor.
Upper floor. Uppermost.
Yeah, uppermost.
I'll put fourth in brackets uppermost.
Okay. Event that's
Thank you.
Considered, you know. Okay. I know it's, sir, so on what sides? If it's on the two sides, what is that? East, west, north, south? I don't have the plan open in front of me.
On the west side, I can also introduce it on the north side, although I don't think standing there they'll be able to see.
Okay, sir, it's not up to you to decide what sides. The member has made a made a motion, and I think she was talking about the two sides, not facing the rear to those houses in the rear, but on the two sides of the deck. When you're facing
west
out,
and north side.
so that would be the sorry. How
West
can it's
and
got to be
north.
east or west or how can that be? It's got to be north, south, or east, west because it's on the two sides. How can that be?
So the front yard faces east. So if it's the
No,
sides, it would be north and south.
The screening is on
the
the
one
sides.
side. The south side is blocked off by the wall. So the terrace actually has three sides to it that are visible. So it would be the north side and the west side that would have screening.
Okay, you're missing the point. We don't want to completely enclose the terrace, but if one side, it's the two sides, not facing out towards the rear, the two sides. If one of them is already a wall, let us know that, and we don't need it on that side. But you got to help, you got to work with us here. We want to move on here. What side, what are the two sides, what is the direction facing the rear?
Direction facing the west.
West, so it's the north and south, but it's either the north or south has a wall or is it open on either side? The two sides, not the front, not looking out, the two sides.
So the north side is open.
So it's only on the north side because you're saying the south side has a wall.
Correct.
Okay. Mishi, is that?
As long as I'm just, it's just the
Yeah.
privacy to the neighbors. That's all I'm concerned with.
The neighbors on the sides, not behind. So it's north-south, but if you don't need one because there's a wall, let us know.
Well, if it's not necessary, then it's
okay.
So privacy screening shall be provided along the north and south sides of the rear terrace on the fourth up or brackets uppermost floor, which is really the roof.
Perfect.
Okay, so we have a mover, a seconder.
Right. Freak far out about that. All in favor? Opposed? I will abstain. So the motion carries 2-1. Thank you, applicant. Thank you, neighbors. Next application is item number 22, 116 HEWARD Avenue. This is an application to construct a two-story rear addition, a rear yard deck, and to enclose the existing front porch. The applicant, we have an applicant submission and a planning rationale. TRCA advises they have no objection. 133 is in support, and we have opposition from 118 and 114 on either side. And I think one of those neighbors is asking for a possible deferral from my notes. We only have two speakers, the applicant, or agent rather, Jeffrey Moot, and the neighbor at 114 right next door. So one of the two neighbors objecting is here to let us know what their concerns are in person. Urban Forestry is requesting condition number 2. And do we have a deferral request or not? I thought I read one there. Oh, this was a very long submission here. Anyway, Mr. Moot, good morning, good afternoon, good evening almost. How are you?
Good afternoon. I'm well, thank you. How are you?
Okay, so just to put myself up to date here. Right, we have the neighbor on either side opposed. And I believe somewhere buried in this letter was a request to defer. Or did I miss something? Does anyone else help me out here? Or maybe it's in the other letter. No one was asking for to defer? Okay. Okay, sir, can you briefly walk us through, I don't know if you've read the objection letters? Oh,
I have.
request for
I'd like-
deferral. It says adequate time has not been allowed, okay, but meanwhile, the guy wrote a long single-page letter, so it bears the fact that I guess they could get this done, and we have both adjacent neighbors, so I assume we don't need a deferral. And here's the letter, that's the other letter, and then we have a letter from Mr. Delgado, who's here to speak to us in person. So, Mr. Moot, can you briefly walk us through your application and why it's worthy of support?
Please. This file before you today is a proposed front porch enclosure of the existing porch and a rear addition. Firstly, this proposed porch enclosure requires relief from the front yard setback requirement. The footprint of the porch is considered existing. We would only be pushing the front main wall out to align with the existing canopy and brick piers. We believe this typology is consistent with recent approvals along the street and with existing conditions, for example, number 118, 133, 180, and 182 HEWARD. The second part of this proposal is a two-story rear addition extending back 3.3 meters from the existing rear wall. We are proposing to construct a total of 276 square feet spread over 2 floors. I should mention this property is considered a row house by definition, as it is the northmost property on a string of 3 attached homes located on a street of predominantly semi-detached and detached houses. The subject property carries an as-of-right building depth of only 14 meters, which is unique rather than the 17-meter depth, which is common for most other properties in the area and the surroundings. We were sensitive to this during the design process. The proposed FSI of 1.12 is consistent or even less than recent construction that we have seen at 162, 166, 168, 180, and 182 HEWARD, which all carry an FSI between 1.11 and 1.19 density.
Sir, what were those addresses again? Were those in the 180s and 160s?
Those are to the north on the same side of the street.
Yeah,
And they range between 162 up to 182.
Okay, so they're quite a distance away. Is the lot patterning similar in that part of HEWARD, or is there a difference?
So the lot gets shorter. I was just about to speak to that, if I may.
Okay.
We acknowledge that our lot size is much smaller than those lots mentioned above. However, the FSI calculation by nature removes the component of, just overall building scale or lot scale. Rather it paints a picture of a particular house size within the confines of its lot size. So the idea that we believe we are proposing a dwelling scaled appropriately to the lot size. That is to say that we believe the proportion and the massing of the house fits well within the scale of the subject lot size. We understand and are sympathetic to the potential impact this may have on our neighboring properties. We held a meeting with both the north and the south neighbors back in late August or early September. And we did decide to reduce the length of the addition from what was previously a 15-foot addition with a raised porch down to an 11-foot addition with only a staircase down to grade, which you see today. This reduction in the depth of the addition also allowed us to remove the need for a rear lot setback variance, which was previously noted on the zoning notice. We are now in line with the required 7.5 meter rear setback. We believe that this modified proposal reduces the impact on the neighboring properties while maintaining a building depth and FSI that is appropriate to the context within which it is located. I did want to just quickly mention, we attempted to add additional square footage into the basement by way of underpinning or an extension rather than above grade solely, but unfortunately it's located low in a flood protection zone it falls into a TRCA sensitive zone. So basement digs and extensions are not advisable. In conclusion, I should also mention that we are happy to and willing to carry on conversations with neighboring properties about the architectural features such as window placement, privacy fencing, cladding, in order to create the best possible addition for all involved. And please note, we do have 12 additional letters of support from various addresses in close proximity within the mailing range of the file. And those addresses are available upon request. Thank you very much.
Okay, so the two people, Mr. Moot, that are here that wrote in opposition are the two other of the row of three row houses. So you're in the middle, and we have the people on either end who are obviously impacted because they were all built as a row house at the same frontage, the same rear yard, everything the same. So I guess they don't want to proceed with an expansion as your client does. And you said you had some consultation and you did scale it back to what we're at today.
We did scale it back. We are on the end. We are on the north end of the three-house row house.
Oh,
and
okay.
So there is a semi-detached. So there are 4 feet approximately between our dwelling and the dwelling to the north. So there is a space.
What's
between
the
us
address
there.
of that one? Is that the gentleman at 114?
That's correct. 118.
118. So that's the other gentleman who rode in and talked about a deferral and disclosed that he's a city employee and all of that stuff. So he's the other in your row, and Mr. Delgado, who's going to be speaking, is in a property not as part of the row, but next door on the other side.
I'm sorry, it's the opposite. Miss Delgado is attached, 114 to the south, and 118 is not attached, and that is the gentleman that you are referencing. Yes.
Okay, so the gentleman who's speaking next is the attached row house. So he's even because there's no zero lot line.
Miss Delgado.
Ms. Delgado. Okay.
Yeah.
Sasha. Okay. Good segue. So we can hear from Sasha Delgado. We do have your letter, and the letter from 118, but if you could just summarize your concerns for us, and we'll see if anyone has any questions for you.
Hi, my name is Sasha Delgado, and I'm 114 HEWARD Avenue. So I'm the middle of the row houses, so the second from the end of the street, and I'm directly sharing that party wall with this house that's requesting this variance.
Yep.
I do want to acknowledge that Mr. Moot has been very gracious about his attempts to appease some of the concerns, but the size of this structure relative to this property is immense, and there is no comparison on the street. We are a very shallow lot. We are at the very end of HEWARD Avenue, and the house, there's a 2-story large semi right behind us, so that's what we look onto when we look out immediately. The only air and natural light that we get to our homes, particularly this row house, is from the corridor created along the backyards, because nothing flows through that big house behind us. So that's very important. I will read the rest of my objection, and I guess I'll leave it to you guys if you have questions.
Okay.
So I would like to impress upon you our lived experience and the impact this requested variance will have on my family, my home, adjacent properties, and the community. The proposed addition at 41% increase to the FSI is excessive given the small lot. It is different. None of the other houses back onto another house and have such a shallow lot. If eventually mirrored by 112 HEWARD, because precedents will be set, so that last house on HEWARD, the only other one after me, could erect the same wall, and it would leave my house in shadows. It would be completely walled in because there's already a wall at the back and one on either side. The inequalities established will make the statement that this home is not entitled to the same access that will be continued to be enjoyed by every other home on the street, and that comes at a cost to our mental health and the sense of place in our community. I want you to understand that the mental health is directly linked to access to natural light, and the only natural light this house gets to the house itself is from the 2 sides of the house. Nothing comes through the wall at the back. The 4 houses at the south end of HEWARD Avenue are on narrow, shallow lots backing onto the side wall of a large 2-story duplex that is an immediate view from the back door and windows, that is in contrast to other houses on the street that are semis and detached homes with wider, deeper lots that back onto a laneway. The corridor created by the continuous flow of the backyards north towards Queen allows for the flow of fresh air and the access to natural light to the adjacent homes, and that we, in the middle row house, only get from the front and rear of the house. These issues of space, light, and air are made more acute by the premium that the pandemic has placed on usable and healthy private space for families. My mother is retired and she lives with us. Her room is in the basement and gets virtually no natural light or fresh air. So she spends her time on the main floor, either in the kitchen to the back of the house or in the living room to the front of the house, as the house is dark even with the lights on. Since the pandemic, my daughter attends school virtually and my work has moved permanently to home. My office is a desk at the window in my daughter's room, as it allows for the flow of fresh air and a view to the trees in the backyards to the north. That's the only view we have is to the north. When all your day is spent on a screen, that view, natural light and fresh air becomes more critical than ever as the environment is otherwise static. We are 3 generations spending almost 100% of our days at home. The backyard has become a haven for a change of scenery, access to our community, a play area for my daughter, a place to escape for some alone time for my mom, an alternative workspace, and a place to connect with our neighbors, with children socializing across the fences from the upper decks. I have lived here for a decade, and the mature trees in the backyards precedes my ownership. This extension violates everything that the city's setback limits exist to protect: privacy, overcrowding, environment. Given our home is at the end of the street, it will cut us off from the community. It will cut us off from the community because the community is to the north. It will surely be the demise of the trees with the footholds dug into the roots, the weight of the extension, the loss of light, air, space, and growth for the tree. In sum, this variance, if granted, will leave our home in shadows, literally in shadows, because 112 can also then erect a wall with the precedent set, and we will have a wall on every single side. It will have negative consequences for the mental health and well-being of my family. It will impact how we access our space, as privacy will be lost in the only part of the yard that is not surrounded by walls, which is to the very, very rear. We will be removed from the community. We cannot play with sight lines to address this. There is no way to change the sight lines of our back door and our window. All this for a bigger footprint that equates to a larger rental income at odds with the city, encouraging affordable housing. It will impact the structure of my home, as the shared wall cannot bear the weight of an extension like that, considering that the original proposal that the homeowner wanted was to also include a 3rd level, and that was denied.
Okay, Ms. Naledi, can you please try to wrap up because you're at 5 minutes? Thank you.
I am wrapping up. Thank you. I am wrapping up. I'm going as quickly as I can.
Go ahead.
Given the tight space with the rear home, there would be challenges if emergency services had to access the rear of my home to access my family. That precious time would be lost. To date, Old Bay Inc. Their approach to the property management has created significant concerns and risks for the adjacent properties in terms of unattended state of good repair, animal infestation, criminal activity. The sound of structure falling, rodents scurrying, and moisture from the adjoining wall of my 4-year-old daughter's bedroom was reported, to which the homeowner indicated she was waiting for this meeting to get her other permits before sealing the place up. Issues have been raised with Old Bay Mill Inc., including detailing impacts on the neighboring families and children, but no effort has been made to address these issues. The concern for this owner to manage an expansion that will impact the structure and safety of the neighboring properties is very much real. We have, as neighboring properties, have acted in good faith and raised issues in a timely manner, but have not received the same timely response. Petitions of support are from homes that are not impacted by this renovation. A letter of support was submitted by a homeowner who does not live in close proximity to this house, stating he's in favor of the extension as it would block out the ugly garages, and commenting on the state of 116 from previous ownership. The extension would block out the 2 row houses at the end of the street, mine and 112. That's what it would block out. The previous owner of 116 was 85 years old when she had to be moved. Neighbors, including myself and her brother, supported the groundskeeping to help her stay in her home as long as possible. When considering healthy and diverse communities, I hope that the city will honor petitions and proposals that support inclusion of all members of the community, their health, well-being, equity, and accessibility.
Okay.
I have no objection to enclosing the front porch or putting a deck on the back, but I do object to an 11-foot extension that cuts me off from my entire community.
Thank you, Ms. Delgado. Sorry for referring to you as a Mystery Delgado earlier. Sasha can go both ways. But thank you for those, and obviously heartfelt and important submissions to you being the middle of the row house in this manner. So that's the last speak. Do anyone have any questions for Ms. Delgado, or we'll go back to Mr. Moot for his rebuttal and his reply to her concerns, and then we'll take it into committee. Mr. Moot?
The concerns of our neighbor. My client also lives on the street, just up on the north side, just up to the north on the same side of the street. She is also an active member of the community, and we have tried to reach an agreement that is satisfactory for all. We have tried to reduce the porch component in order to control the potential overlook from this subject property to the other adjacent properties. I cannot speak to the future plans of the south neighbor 112 in terms of a potential future renovation. What I can say about our proposal is that we have attempted to respect the rear lot setback in order to ensure that you do receive the light and the air that you've described. Of course, we intend to repair the property as part of the renovation. I should say that the property is being designed as a family-sized rental unit. We are excited by the prospects of another family being able to live on HEWARD. It's a beautiful street. It's a great community. It's a great street for all. And pertaining to the concern around landscaping and specifically the trees, urban forestry has assigned condition number 2 to the property, and so they will be reviewing the file prior to any potential building permit issuance, and they will ensure the health and of the trees identified in the notice, as well as my client intends to do the same. The property has been in a little bit of a holding pattern for the past year or so. This as part of the planning process and leading up to the hearing today. And so our intention, hopefully, is to start to tidy up the property by way of an overarching renovation of the house. Thank you very much.
Oh yeah, there was one more thing. I think I don't know if you've answered it yet. In terms of, I may have already asked this. If I did, forgive me. What the current FSI is before the proposed. You're allowed 1 times coverage. You're seeking to go to 1.12. What is it currently? In other words, it would be the same as the other 2 in the row house, just to see how big of an.
Yes. So the existing currently is 0.794. So 0.794 and proposed 1.12.
So it's like 1.8. Okay, that's all I need. So any other questions for Mr. Moot or Ms. Delgado, or are we ready for motion?
I'm prepared to move a motion for approval. Variances requested are minor in nature and meet the 4 tests in the Planning Act. And that's subject to the forestry condition.
Okay, so we have a motion for approval subject to urban forestry condition number 2. Is there a seconder for that motion? Ms. McCluskey, all in favor? Opposed? I'm opposed. Okay, the motion carries 3 to 1, and the application is approved.
Okay, we just need to take a quick break to switch the
I
YouTube
see.
stream because
Okay.
it's running out. So anyone who is paying attention now on YouTube, you will have to switch. There will be a second PM session that will be started right now.
Hmm.
Say 10.
Can we start? Dunbar?
This is the longest time I've ever worn a mask. All COVID.